Check 1 2, check, check.
We're going to be here, right? So I'll just put the panels here, like, is that okay?
Where do you want them to
Yes. I haven't seen him yet.
Okay, because I don't know what salespeople look like. That's okay.
All right, good morning, everybody. For those of you who don't know me, I am Michael Scharf, the co-dean of the law school, and it is my great privilege to welcome you to this wonderful conference that Professor Juscelino Collares has put together. It's the second annual conference, and one of the things that Juscelino and I have been talking about for years is the fact that our Cox International Law Center, which is the 12th ranked international law program in the United States under the U.S. News rankings, has been known for a long time for public international law. We do have the great Canada-U.S. Law Institute Conference, which is private international law, but we really wanted to make a big splash in the world of international trade law and customs law. And this is Juscelino's expertise, of course. He's on the NAFTA Register of Arbitrators, and Juscelino is also the Associate Director of our Cox International Law Center. And then in his spare time, he is the chairman of our faculty senate. So it is really gratifying to me that he has been able to launch this annual conference and that this has become a really big thing nationally, where people know about this, they tune in and watch our webcasts, and they know that if you want to know what is going on in the cutting edge of international trade law and customs law, this is the conference you need to be at. For the last 3 years, we've been blessed to have a judge from the U.S. Court of International Trade here. And once again, we're very happy to have our judge with us, which will anchor this program. So without further ado, let me turn things over to Professor Collares and wish you all a very successful conference. Thank you.
Thank you, Dean Scharf. Good morning. Welcome to Case Western Reserve University School of Law, second International Trade Law Fall Update. That's a mouthful. Thank you also for our sponsors, the American Society of International Law and the Customs and International Trade Bar Association, the Cox Center, and the Greater Cleveland Lawyers Group. I am Professor Juscelino Colares, and I'm your host. I see myself as a co-organizer of this event with the Honorable Judge Gordon, Leo M. Gordon, U.S. Court of International Trade Judge, to whom I feel greatly indebted, and from whom I flagrantly stole some ideas to put this conference together. I will introduce Judge Gordon and engage him in a roundtable conversation after some brief remarks. Now, please join me in welcoming Judge Gordon, the distinguished panelists and moderators, and our wonderful alumni participants. As the conference theme suggests, we are gathered here to discuss emerging trends in litigation, as well as the deployment of new tools that are ancillary or additive to the more traditional customs and trade remedy litigation context. These ancillary tools are quite varied in that some of them are new, the Enforce and Protect Act, EPA, those administrative proceedings under EPA, while others are old, sections 337, 232, 301, and reverse false claim actions. They are also varied as to how they come alive. In one end of the spectrum, you have reverse false claim actions. In most other cases, proceedings are instituted by beginning administrative proceedings before different agencies, namely U.S. Customs, U.S. Department of Commerce, United States International Trade Commission, etc. These enforcement tools, however, share one thing in common. They may all end up in the United States Court of International Trade. The U.S. Court of International Trade is an Article III court under our Constitution. The judges enjoy an appointment based on good behavior, typically for a lifetime, after being nominated by the President and confirmed by the U.S. Senate. Like the U.S. District Courts, it is a trial-level court with a rolling docket, meaning that cases are assigned to its judges as they are filed. Unlike the district courts, the CIT has nationwide jurisdiction over a specific subject matter, cases arising under the trade laws of the United States. The court has an authorized complement of 9 judges from a variety of backgrounds, including government service, private practice, and academia, and a courthouse located in New York City, just across the street from the Southern District and the Second Circuit courthouses. It's on Duane Street. Nice black box, glass building. Today, the CIT has jurisdiction to review trade determinations that come from 6 different federal agencies: Customs, Homeland Security, Treasury, Commerce, the International Trade Commission, and the U.S. Department of Labor. Thus, the court has jurisdiction over litigation that helps set the rules of the road for the great economic engine with which the United States is blessed. Having the government always appear as a party in no way interferes with the variety of remedies the CIT can provide. In this respect, the subject matter-based CIT functions like any other Article III court. Cases may always be brought by private parties, importers, domestic industry, foreign producers, and foreign governments. Actions before the CIT obviously allege that are violations of our domestic law, which of course incorporates international agreements, but the court can provide concrete remedies, including declaratory relief, mandatory injunctions, the return of improperly imposed duties, etc. In sum, the CIT has all remedial powers in law and equity as conferred by the Judiciary Act upon the district courts of the United States, with the distinction that it is a national court with a nationwide jurisdiction. Two major types of litigation come before the court. The first major type, of course, involves customs litigation, which typically involves classification disputes under the harmonized tariff schedules of the United States. In Ford, for instance, one of the recent cases, Judge Gordon and I, that have been decided at the CIT, Judge Barnett, but Judge Gordon and I will discuss. The issue of tariff engineering is the ultimate issue. To be clear, tariff engineering is the principle that merchandise is classifiable in its condition as imported, and that an importer has the right to fashion merchandise to obtain the lowest possible rate of duty. Possible meaning legal, of course. The case involves commercial vans imported from Turkey as passenger vans, thus paying a lower import duty, 2.5%, from which Ford removes the second row seat after clearing customs, but still in the port area, only to deliver them as cargo vans. The Ford vans, if deemed cargo vans, would receive a much higher duty, tenfold higher, 25%. Other customs issues involve the value of goods, where they come from, and how they have been tested, etc. The second major group of cases before the CIT involves challenges to investigations by the U.S. Department of Commerce and the International Trade Commission, where anti-dumping and countervailing duties may be imposed. For example, 5 years ago, Whirlpool Corporation, a domestic manufacturer of large residential washers, came to Commerce claiming that washing machines from Mexico and South Korea were being sold in the United States at prices below those charged in their own markets, or at prices insufficient to cover the costs of the goods sold. It's called dumping. Whirlpool also argued South Korean producers received subsidies from their government. So Commerce investigated washing machine producers from those countries, found dumping as to Mexico and South Korean producers, and illegal subsidization as to South Korean producers. Upon the ITC finding that such unfair trade practices injured domestic industry, Commerce issued an order and imposed anti-dumping and countervailing duties. LG Electronics, a South Korean respondent at the agency level, came to the CIT to contest only the ITC's affirmative duty determination, on the notion that if you kill an injury finding, you kill basically the Commerce can't issue an order. I hope my students remember that. So basically, they charged the finding of injury by the ITC, that the domestic industry had been harmed by reason of the imports of the dumped and subsidized washers from South Korea. So it's an injury challenge to an injury determination. Ruling on a motion for judgment on the agency's record, Judge Kelly upheld the agency's action on injury as supported by substantial evidence on the record and the order stayed in place. Substantial evidence standard is the most common standard of review applicable in trade cases. Other matters that can appear in the CIT docket include also claims by the government for civil penalties as a result of fraud, gross negligence, or negligence in the importation of goods, suits for liquidated damages, and government suits on bonds to secure payment of duties when goods come into the United States. Then there's other collection actions by the government. One should also be reminded that beyond these specific types of actions, so there are two major groups, essentially customs, trade cases, and then these, enforcement of these civil penalty types of cases. Section 1581I of Title 28 of the United States Code also grants the U.S. Court of International Trade broad and exclusive jurisdiction over any action commenced against the United States, its agencies or officers, arising out of any law pertaining to revenue-raising or non-revenue-raising tariffs, fees, duties, taxes, or quantitative restrictions imposed on the importation of merchandise into the United States, or pertaining to the administrative or enforcement of such matters. The one major exception are actions reviewable by NAFTA panels, which, depending on how ongoing NAFTA negotiations go, may come back to the jurisdiction of the CIT. As you know, USTR has indicated that the United States wants to remove the trade dispute, the binational review on trade determinations from the NAFTA, meaning basically Chapter 19 of the NAFTA. As we conclude this introduction and transition to our discussion of the different topics in this second trade update, an important point to retain is that any member of the trade bar knows that he or she can come to the U.S. Court of International Trade with the confidence that the review will be conducted in accordance with the norms for established and uniform standards of review. And this is a big deal. You know what standards you're going to have, and you know that the court applies these standards in a consistent way. By applying these norms, the U.S. Court of International Trade has contributed to the achievement of the constitutional mandate under Article 3, that is the source of its original jurisdiction. I will now proceed to a roundtable discussion with Judge Gordon. We will have ample time at the end for questions and answers for members of our audience. I met the Honorable Leo M. Gordon over the phone 12 years ago when he was the clerk of the court on a desperate call to ask for some remand determinations that I was having a hard time finding, and which were essential to a particular empirical work I was doing. The data I obtained, thanks to Judge Gordon's invaluable assistance, helped me conclude my research. He wasn't a judge then. I don't think I would have gotten to a judge by just picking up the phone. But he was incredibly gracious, and he provided this data and really saved my summer that year. That was 2005. So last year, I reached out to him again to ask for help in creating a complete new trade update in Cleveland. He again came through, and we've been in touch since. Judge Gordon is a Phi Beta Kappa graduate of the University of North Carolina at Chapel Hill, obtained his degree from Emory University School of Law. His career began over 3 decades ago as assistant counsel to the Subcommittee on Monopolies and Commercial Law, Committee on the Judiciary, U.S. House of Representatives. All customs and trade attorneys present owe him a huge debt of gratitude, as he was the principal attorney responsible for the Customs Court Act of 1980 that created the U.S. Court of International Trade as an Article 3 court. Following his time with the judiciary, Judge Gordon served on the staff at the court for 25 years, first as assistant clerk, then as clerk of the court, until his appointment to the bench by President George W. Bush in 2006. As many here present, I know of his great dedication to public service, and I have been benefited very much from his wisdom and kindness. Without further ado, I give you United States Court of International Trade, Judge Leo Gordon.
Thank you, Usolino, for those kind words. I'll start with the usual government employee caveat. Any remarks that I have today reflect solely my own personal views. I'm not here to speak on behalf of any of my colleagues or the court as an institution. Before we begin the roundtable interchange, I thought I'd make a few comments from about the 10,000 foot level. Some of this may seem fairly pedestrian, but for folks who don't regularly appear before the Court of International Trade or are much engaged perhaps in the administrative process and don't get a chance to litigate many cases, there's some things I think you ought to know about kind of the current state of affairs at the court. But by statute, the court has a complement of 9 judges. We have been in a circumstance, 9 active judges. We have been in a circumstance where we have been as few as 5 active judges in the last 2 years. Within about the last 12 to 14 months, we've gotten 2 new appointments. One, Judge Jennifer Cho Groves, who comes to the court from a private practice background, doing a lot of intellectual property work, and before that worked at the United States Trade Representative, going around the world negotiating intellectual property agreements on behalf of the United States. And before that, she was a prosecuting attorney in New York. We were also joined by Judge Gary Katzman, who for a large part of his career was at the U.S. Attorney's Office in Boston, Massachusetts, and for the last number of years served on the Massachusetts State Court of Appeals. They are both excellent and wonderful additions to the court. We also in the last, so now we're at a complement of 7 active judges and 5 senior judges, and in that same period of time, the court either through a form of retirement, going inactive senior. Judge Carmen, Judge Sakalas, and Judge Barzilai opted for that status, and unfortunately, a year ago, we lost Judge Pogue very suddenly one night to a heart attack. So, in terms of complement of judges, the court's been under a little bit of stress, and it clearly has had an impact on our ability to get to the dispositional work. But on that front, the court's more than made up for it. Right now, the court, to this date, has issued 145 slip opinions for the year, and at that rate, the court will, in all likelihood, end the year with the single highest rate of dispositional slip opinions in the last 10 years and the third highest in the last 20 years. So it's clear that all of the judges, active and senior, are getting to the business of the court and issuing the decisions that affect the litigants. There is no doubt that the work of the court is increasing. One of my colleagues recently taught an in-house course on trade law, focusing on the Department of Commerce, and in doing the research for that, we've learned that there are now 60 more dumping and countervailing duty orders on the books today as compared to a year ago. If you figure that a certain percentage of those are going to end up in challenges before the court, you come to realize quite quickly that the workload of the court and the bar, both government and private, and the stresses that are associated with those things are beginning to increase. And for those of you who are quite familiar with the work in the dump countervail area, new orders spawn administrative reviews. So it's just not the judicial review of the initial investigation and the outcome both at the ITC and the Department of Commerce, but there's the going forward work and successive proceedings. So the reality is there's plenty of work for everybody, and the dispositional stresses are going to continue. You couple that with what we understand is an increased focus by the executive branch on enforcement efforts. We're seeing an uptick in the number of civil penalty and collection cases that are being brought at the court. Those have their own interesting and unique challenges, which I'll touch on in a little bit in the round table. The court works very hard in terms of its dispositional work. We have an internal benchmark of trying to decide cases in about 90 days. The reality is we hit that mark a reasonable portion of the time, but just given the workload and the complexity of some of the cases, we're not there 100% of the time. The court works very hard at making sure that no case stays on the docket for more than 365 days once it's ready for decision. And again, every once in a while, a couple of those rear their head and are on our plate for longer than perhaps they should be, but the court continues to work very assiduously at reducing that number and down to zero. In terms of things that directly affect the bar, the court works very assiduously with its advisory committee on rules in addressing improvements in the litigation process and concerns of both the bar, government and private, and the court. There have been a number of changes over the last 12 to 24 months that folks should be aware of. In the trade area, probably the two most significant changes have to do with creating a template and somewhat more automaticity around a statutory injunction to enjoin the liquidation of entries that are subject to trade litigation. Also, in an effort to streamline the process both between the CIT and the CAFC, the court adopted a rule that creates a unified appendix to the main briefing in a trade case. So then rather than the underlying documents from the administrative record being filed with each brief, there's a consolidated appendix that's filed after the last brief has been filed. That pretty much follows the practice and the rule. The rule and the practice in the Court of Appeals for the Federal Circuit. In the customs area, as a result of a decision a couple of years ago that raised some concerns about the timing sequence for getting an extension of time to remain on the reserve calendar, the Court's Advisory Committee took a look at what we call the calendar management system in customs cases. My wife is trying desperately to get me to laugh here by interrupting me with her. So it's just about to go into effect, if it hasn't already. There's a brand new calendar management system that deals with the reserve calendar and the suspension calendar. There's some new timing sequences for customs lawyers who are bringing denied protest actions to the court. You need to take a look at this. Also in the customs area, the court has had on its books for a while what we call a small claims pilot project. It's kind of running its course in terms of its initial timing. It very candidly has not yet been used. The court and the advisory committee are seriously looking at extending the program and finding ways to promote its usage going forward. I think two other things I might talk about quickly in the customs arena, both in traditional customs cases and in cases brought by the United States. It's the issue of summary judgment. The court adopted a rule a little bit more than a year ago that's akin to the practice in district courts, that when you file a motion for summary judgment, you need to file a separate statement of material facts to which the other side must respond. That ultimately consolidates all of the material facts into statements that are easily digestible by both sides and the court, as opposed to having to hunt and find them in the middle of a brief. If anybody's been following the decisional work of the court, you will notice that perhaps more frequently than ever before, the court is denying motions or cross motions for summary judgment. There are some significant questions that are out there about genuine issues of material fact in dispute. It doesn't mean that the cases ultimately go to trial. I think what's happening is the court is identifying areas where additional work needs to be done by the parties, and in certain circumstances, those cases have actually come back to the court and been decided on cross motions for summary judgment. The Ford case is probably most illustrative of that point. There seems to be some modest increase in use in the court's intra-court mediation program that's governed by a court rule and a set of guidelines. The focus there tends to be in one of three areas: civil penalty cases, classification cases that are one-offs. There may be a provision in the HTS-US that's been modified, and so a particular set of imports came in when the HTS read one way and now it reads another way, so you've got a one-off. And then we've seen some mediation work in the area of evaluation cases. In terms of another trend line, if you look about the last 18 to 24 months in trade cases, you'll note that the court has been dealing with the issue of the doctrine of exhaustion of administrative remedies, perhaps a little bit more frequently than it has in the past. I'll leave you to read those decisions and draw your own conclusion as to what contributes to that. With that, I'll stop. That's kind of 10,000-foot view trend line of things going on at the Court of International Trade. We still have 2 vacancies. There are no names that have been submitted by the President to the Senate, so the reality, given the pace at which things are moving, the likelihood is that those two slots will not be filled at least until the end of the spring of 2018. So the court's going to labor with a slight reduction in its complement, and so I can tell you on behalf of my colleagues, we're all working hard, but we also need your understanding that there's just so many of us, and if you want us to do a thorough and complete job, we ask that you have a little bit of patience.
Thank you, Judge Gordon. The theme of the conference is this, what we tried when we established it is we were trying to focus not only on, the classic, divide between customs and trade law, customs law and trade law cases, but also and the traditional, actions that are filed or instituted under these particular areas. But we wanted to talk about, proceedings that are ancillary, that are new. Some of them are new, some of them are old, and because they, in a way, they are likely, especially in terms of the second panel, they are likely to become, certainly in terms of the first panel with EPA actions now, with Customs issuing its first decisions, determinations, you will see a rise in that end, as well as in the trade cases, the potential 232, 337s that have been with us for a long time, will also be are also part of this effort, which we see is part of an effort by the administration to improve enforcement, but not only, also by private parties, by domestic industry. And you also see, of course, a response by the importers on the importer side on that. So on this axis, on the notion of ancillary customs and ancillary trade remedies theme, let me start by asking you a question, Judge, on a set of recent customs cases. United States v. Rupari, Judge Katzman decision, and United States v. American Home Assurance Company, a decision by Judge Moore of the Federal Circuit. These cases involve actions brought by the government to collect on civil penalties for fraud by an importer and to collect prejudgment interest on a surety, respectively. So how frequent are these actions in the CIT docket? And if you could comment on the major points of law in this area and give us your take on these cases. And then if you could go into Morex, because you've recently...
Well, Morex is AFA.
Yeah.
So on the enforcement actions by the United States, as I said in my opening remarks, we're beginning to see an uptick in these. And the enforcement actions are not only against the importers, but we're also seeing perhaps even an uptick in enforcement actions or collection actions vis-a-vis sureties. So let's spend a couple of minutes talking about these cases. In the question in Rupari was a bankruptcy filed by the defendant in the 592 civil action. Here, the bankruptcy was filed during the course of the civil penalty litigation. And the claim in the civil penalty action was for fraud. So, kind of breaking this down, the court tends to see more enforcement actions by the government in the civil penalty area for negligence or gross negligence. Civil fraud, much less frequently. The difficulty is, if you are a practicing customs lawyer, you know that the administrative process with respect to civil penalties takes a fair amount of time. So by the time the case gets to litigation, one of the challenges for the government and for the court is that there may not really be a live defendant. All right. So in Rapari, there was a live defendant, but the defendant filed bankruptcy. Right. And so the critical question there is, what's the effect of filing the bankruptcy on the civil penalty enforcement action by the government? And that was the question that Judge Katzmann was faced with. And in the end, what he basically said was, no, the automatic stay, the statutory stay that one normally gets by filing bankruptcy is not going to be applicable to stay the civil penalty action. Now, this was a fraud case. So the open question is, would the result be the same in a negligence or gross negligence case? Some of the critical language in Judge Katzmann's decision dealt with the statutory exceptions to the general rule regarding the continuation of the action, and Judge Katzmann was concerned about some of the policy implications with respect to the bankruptcy rules and not allowing them to become a safe haven for wrongdoers. And there are two tests that Judge Katzmann focused on, one having to do with pecuniary effect, and the other one was the public policy. And the court observed that the government was only seeking to fix a money judgment, not execute on the money judgment. So the interesting question is, if the facts are somewhat different in the next case, would you end up with a similar outcome or same outcome? And I think only, time is going to tell.
So what you're saying essentially is what the government was trying to do in the case is basically get in line.
Correct. It wanted
instead
to
of actually
effectively
enforce
register.
the debt.
Correct. Now, in American Home Assurance, and then there's a couple other cases, some that involve surety companies and some that involve private non-surety companies, importers. A couple of important things. In the American Home Assurance litigation, the government sought statutory prejudgment interest and equitable prejudgment interest. All right, so let me touch on the statutory prejudgment interest. There, the government was seeking interest under a statute, 19 U.S.C. Section 580, that provided interest in a suit on a bond at a statutory rate of 6%. The initial argument was that the government said that statute was a penalty, right, and not a prejudgment interest provision. The courts never quite dealt with that issue. The long and the short of it was the Federal Circuit said 19 U.S.C. 580 applies. The private party defendant, the surety company, said that statute only applies to regular customs duties, right? Normal duties that you pay based upon classification, valuation, country of origin, et cetera. The government was suing here to garner 580 interest for the collection of anti-dumping duties, right? So the Court of Appeals said, no, it applies to both. 580 applies to regular duties and to dumping, theoretically, and countervailing duties, right? So then now you have statutory prejudgment interest. Now, what do we all know from our days in law school, right? Equity acts in the absence of a statute. Well, the Federal Circuit came along and said, yes, you've got statutory prejudgment interest, but we're not going to automatically say the government is not entitled to equitable prejudgment interest. And it sent the case back to the CIT to say, look at the circumstances and see whether equitable prejudgment interest would be appropriate. All right. So the follow-on has been that the CIT has had to look at, in each case, case-by-case basis, whether facts and circumstances, whether the equities weigh in favor of the granting of equitable prejudgment interest. Well, in the circumstances that we're in, right, where interest rates are low and you're being the government's being compensated at 6%, right? Court came along and said, and the court did a full analysis. It looked at the interest rates over the period of time involved in the litigation and concluded that those interest rates were well below 6% and said no, under those circumstances, the government was not entitled to equitable prejudgment interest. So equitable prejudgment interest is not automatically precluded. That's the bottom line of these cases. And it has to be a case-by-case analysis. Post-judgment interest, while the statute does not specifically apply to the Court of International Trade by virtue of 28 U.S.C. 1585, where the court possesses all powers in law and equity, the courts engrafted the post-judgment interest statute that applies in other forms of civil litigation, particularly in the district courts. The other piece of this puzzle, particularly circling back to 592, is that the court is finding itself dealing with defendants who are participating in the litigation all along the spectrum. Some fully litigating and defending their rights, and some who show up for a period of time and then exit the litigation, and then some who never show up at all. And so the challenge in those circumstances is typically not the issue of liability, and typically not the issue of whether the defendant owes the unpaid duties, but the real challenge lies in the determination of the amount of damages. And there's a decision involving Horizon Products in which I kind of lay out the panoply of options and approaches that the court has taken in dealing with the variety of scenarios where you deal with default judgment.
Thank you. Still on the customs side of the bar, the most interesting case is Ford, I mentioned in my remarks, which a tariff and engineering case involving commercial vans. This case combined old Supreme Court precedent, classification cases like merit, sugar cases. These are old, meaning 1891 type of cases. Merit, the sugar case, the Seaburger, the cotton plus wool sweater case, and Citroen, the pearls case. With the comparably more recent Federal Circuit 1994 Marubeni decision or test that looks into a vehicle structural and auxiliary design. Judge Burnett's decision is under appeal, and I understand that comments here are very, you would want to be circumspect. But what do you draw from this case in the sense that, what do you draw from the case generally, and today with the spread of rates being such, as tariffs over time have gone down, there might be still tariff engineering going on, but it may never get litigated because the differential in tariffs has become so small. In this case, the difference is tenfold. It's 2.5 if you import the vans as cargo vans. Do I have it up? As cargo vans, and 25% if you import them as passenger vans.
No, the other way around.
The other way.
The other way around.
Because there was a seat in the back.
Right.
So 25% if you import them as cargo vans, 25% if you import them as passenger vans.
So the tariff engineering, I'm going to assume most people know, but I'll take about 45 seconds. Tariff engineering, at the end of the day, is where there are consultants to industry who look at the tariff schedules and help the folks in the industry design their product in a way that takes advantage of the tariff schedules. Bottom line, the goal is to design the product and have it imported into the United States in a way in which you pay the lowest amount of duty. I think candidly, no matter what the spread is in duty rates, somebody's always gonna be engaged in that process, right? Because there are, between the different trade agreements that exist out there on a bilateral or multilateral basis, plus the fact that, there's always some spread in the tariffs, despite the fact that there was at one time when the Doha round and the like were still alive and well, there was a drive to zero on tariff rates. But the reality is, tariff engineering is going to be around. The degree to which it exists is kind of unknown by somebody like me. I think you'll have to ask, the customs lawyers, the regular practitioners in the audience, how frequently it occurs. But we've seen it candidly from time to time in litigation. I think for those of you who are old enough to remember the sneaker wars, for those of you who think that when you were buying sneakers in the 70s and 80s and you liked the designs, it was all about fashion and getting the customer in the store to buy them. Trust me, the percentage of leather or plastic, et cetera, on the uppers of the sneakers was all about tariff engineering and bringing those sneakers in at a favorable rate. Probably more recently, tariff engineering reared its head in the sugar industry, and Judge Barnett, in his two decisions, kind of outlines the more recent history.
The summary judgment and the final.
And so now you have tariff engineering. It showed up in the automobile industry, right, in the Marabini case with the Nissan Pathfinder, whether it was a cargo van or a passenger vehicle, and now it shows up in the Ford case. I think the interesting observation about the Ford case is you're not talking about pre-importation activity. You're talking about post-importation activity while the merchandise it's gone through customs, but it's still in the port, right? So you have this interesting interplay, right, between the concept of, what's the specific language, guise and artifice, right? Guise and artifice, right, and condition as imported. Now, from a procedural perspective, there were two decisions in Ford. Judge Barnett, in the initial decision, denied the cross motions on summary judgment because there were factual issues relative to the cost of the reduced cost rear second row seat. Obviously, more discovery was done. The facts became clearer, and then the case came back and was resolved on cross motions for summary judgment. There was a lot of discussion about intended purpose. The court comments that it did not believe that it was relevant, and the court goes through a fairly detailed analysis pointing out the differences between the facts in this case while applying the Marabini factors. I think it'll be interesting to see what happens at the Court of Appeals for industry, whether it's the automobile industry or other industries, and for customs lawyers and consultants. I think this potentially is the outcome at the Federal Circuit, and who knows whether it'll go to the Supreme Court beyond that. I think it's going to help shed light on whether tariff engineering is going to be alive and well going forward, or it's going to have to morph into something somewhat different along the way. I think one of the interesting things about the second decision is the court declining to engage in the use analysis, which emanated from the GRK decision by the Federal Circuit, which seemed to implicate that use can spill over into eo nomine classification cases, and the court here declined to engage in that analysis. I think the major takeaway on the Ford cases is stay tuned. I think it ultimately will be interesting fodder for not only for conversation, but probably some law review articles going forward.
We're about to run time. Let me just ask you one more question.
Sure.
And a couple of trade cases that have been subject to remand. The Itochu v. United States, which is a challenge to the Commerce final second administrative review determination on an anti-dumping matter, where Judge Rustani meticulously goes through the plaintiff's motions for judgment on the agency record, remands Commerce's final results based on a couple of those motions, while also granting Commerce's motion for a partial remand. The other case is Meridian, where Judge Musgrave, I think, Judge Musgrave, he renders a decision and where he, in the opinion, disagrees with an interpretation that Commerce has on his second remand, but he says, I'm not gonna, he mentions it in dicta because he basically agrees that the parties, Commerce and the importer, basically agree to conclude the dispute by asking the court to sustain the agency's action. So my question here is two questions, and I'm going to ask you to be a bit briefer, if I may.
Sure.
This might be my only chance ever to ask for a judge to be brief. First, without addressing Judge Rustani or Musgrave's judicial temperament specifically, what factors drive a judge to pull the plug on further remands or makes him or her issue further remands?
Well, these cases raise two things: the question of fraud on the proceedings and transparency. That's kind of what's going on in the Itochu case. There was also a case called Hybe Golden Bird that also dealt with the issue of fraud. And at the end of the day, particularly in the Itochu case, you're dealing kind of with the story behind the story. You know, when lawyers come to court, they tell the court what they want them to know. But there's always a story behind the story, and kind of the curtain got peeled back a little bit in the Itochu case, and Judge Rustani commented on kind of the peek behind the curtain, so to speak, and was basically very concerned about transparency and the integrity of the proceeding and the possibility of fraud on the proceedings, whether it's fraud before the agency or fraud on the court. And to a certain extent, that's also what was going on in Hybe Golden Bird, but more about the fact that fraud potentially was being perpetrated on the agency in the Hybe Golden Bird case because because the importer was basically importing for others who had a much higher duty rate. The possible
untoward conduct is by the petitioner at the agency who casts a very wide net in terms of
in Itochu, you dealt with a request to review over 200 respondents, which then got slimmed down. And the real question was the domestic making a private settlement with these companies, and therefore money that should have been legitimately collected by potentially collected by the government to offset the unfair competition behavior was going into the pockets of a private party as opposed to the government. And basically Judge Rustani remanded to Commerce and said, ask the domestic a whole lot of questions and get satisfactory answers. The Judge Musgrave situation is not common, but it's not uncommon. I think it reflects the tension between the agency and the court in the understanding of what's going on in one of these proceedings and what's being decided. My view on it is that sometimes these things go off the rails because of the pressures of time, because the agency sometimes writes a C+ paper instead of maybe a B+ paper. They don't quite get to dot the i's and cross all the t's. And so as a result, some things are not necessarily explained as well as they could be, and you end up in a tension between the court and the agency. How many remands, kind of implicit in your question is how many remands are too many? Judge Rastani and her husband wrote a very interesting law review article on this. And basically the question is, when is enough that the court effectively will issue a declaratory judgment or an affirmative injunction and order the agency to do X or Y, or the court will step in and in itself act as if it was the agency and make the final decision. I just think it's a case-by-case circumstance. If you're dealing in a case where there's 2 remands, I would say to you, if I was handicapping it, highly unlikely. If you're dealing with a case where it starts to get beyond X number of remands, then I think the tension really starts to rear its head. And the question is, just exactly what's gone on in the case. And, we're just going to have to see. It's not, the under protest is not common, but it's not rare either. And I think it's just one of these things that is a case-by-case determination. And, there just may well be a disconnect. And if that happens, it gets sorted out in the mix.
Thank you. We have some time for questions. Anyone in the audience would like to ask questions, raise your hand. Yes, sir?
Just wondering, when the court is shorthanded, does that make you think longer about setting precedent with less judges, or does that make you want to decide faster, if it's like a quick, when you said there's a separate statement on summary judgment and just clear the backlog?
Well, I think each judge brings their reasoned decision-making to every case. Do I think that a judge takes less time or more time because there's a backlog? I think a judge goes about trying to do the best job that they can in concert with the oath that they took. Judges are human beings. They understand the time pressures and the need to get the litigants answers. For me, if I have more things in the pipeline, do I work longer hours? Do I work faster? Do I work harder? We all try to work as fast as we can and as hard as we can. I don't think that we would take less time and inadvertently, or I should say consciously, choose to take less time and shortchange somebody on our reasoned decision-making or justice. We're aware of the time pressures. We try to push the stuff out as quickly as we can. Some of it depends upon whether you've got a case that's got 2 issues or you've got a case that's got 12 issues. If you assume, for the sake of argument, that it takes a law clerk/judge about 5 days to go through and digest what's in the briefs, look at an administrative record, and write a first draft, and you've got a case that's got 12 issues, it's not going to get done in a week and a half, right? Whereas if you've got a case that's got 2 issues, and judges will make adjustments. They'll understand if something's got a few more whiskers and, move something up in the queue and move something else down.
As far as like the court being shorthanded, like current situation, there's not going to be
The chief judge does a great job of distributing the cases evenly amongst the judges. The chief judge is very receptive to making adjustments when judges feel that they are burdened with overly complex cases that are sucking up a lot of time. And so, if I'm doing the queue 3 new cases and it turns out that I'm overburdened, I may get 1 or 2 new cases, and then, it'll even itself out over time. my next queue, I may do 3 cases, and I say to the chief judge, I've taken care of X, Y, and Z, and so now I'll get 4 cases, all right?
And X, Y, and Z is not the case.
No, X, Y, and Z is not the case.
Any other questions? Mr. Yarmick?
Your Honor, I had an interesting conversation recently on a 592 penalty case, and I'm hoping maybe you could pull the curtain back a little bit. And I'm wondering if you're getting the same message that I got, which was there are going to be more trials. And if I step on a plane to take a deposition, we're going to go to trial. And I wanted to ask if the court is hearing that same message from the government attorney, and if so, what is the court doing to prepare for that, particularly since you're shorthanded?
The enforcement philosophy in civil penalty cases is something that's committed to the discretion of the Justice Department in consultation with its client. What I heard is what I reported to you earlier today. There is a likelihood that we're going to see an increase in enforcement actions in the civil penalty and collection area. The degree to which they go to trial, as opposed to summary judgment, I think is just going to depend. Do I know that the Justice Department has made some adjustments in personnel with respect to this issue? Yes. I think some of it's going to candidly depend upon the status of the putative defendants, right? There may well be just as many of those cases that end up in the default judgment scenario under Rule 55 because the defendant chooses not to defend or they don't exist anymore, right? So will there be more trials? We'll see. If it turns out there are going to be more trials, the court's prepared to deal with it. And in some respects, as strange as it sounds, right, being involved in a couple of day trial and a court making findings of fact and conclusions of law may ultimately be a lot simpler than sitting down and having to write a very involved decision on summary judgment. If it turns out that we've got a challenge, then like anything else, the court will go to the bar and find a way to work it out that will be in the best interests of all the participants, the government, private litigants, and the court as an institution.
Thank you. A reminder to my students in civil procedure, just remember, Rule 55, it's not that rare, right? Default judgment. All right, any more questions?
Yeah.
One from this side?
In regard to tariff, would you call it tariff engineering?
Yes, tariff engineering.
That's what lawyers do, very, similar to a tax
Right.
intent, and so I found interesting this, what you call the standard intent, the background intent of purpose of the.
Right, that was one of the issues in the Ford case. One of the arguments.
It's a really slippery standard. I mean, we're just like a mens rea analysis of what do they have in mind on making a product? It's to get the lowest tariff, which I think that's admittedly.
Well, but there's Supreme Court law that basically says there's cases that deal with that. Intent was argued by the government, and the court basically said we're not going there.
Very good. That makes sense. And then why do you think there's more dumping cases right now than there were a year ago? 60 more.
Dan? The answer is, as strange as it sounds, activity in the enforcement of the international unfair competition laws, dumping and subsidy law is counter-cyclical, right? So we're in an environment where there's a significant uptick. Dan's going to be in a much better position to address that at the Department of Commerce level and the why and what domestic industry is saying to them as compared to the court. You got to remember, the court's in the most reactive position that one can be, where the courts in general, we're at the end of the process, right? We get what we get. We don't have any say in what comes in the door. And so if there turns out to be a spate of trade cases, there's a spate of trade cases and we got to deal with them. Heather.
Thank you.
I'll answer the second question first, all right? We're dealing with international unfair competition laws. Any time that parties, in this instance domestic and foreign, sit down and start to discuss things that relate to market share, pricing, et cetera, concerns, bells and whistles should go off, because you've got the domestic competition laws in the form of the antitrust laws. Not for me to say. I'm going to assume that the people involved were smart enough to figure out what they were going to do so that they didn't violate the antitrust laws. But I remember way back when I first got involved in this business, some of the scions of the trade field were actually folks who had made a name for themselves in the antitrust world. And they talked early on about the crossover and some of the potential problems. My view on it is courts are asked to decide certain things. I don't think it's the court's business to get into the behind the curtain, right? As I said, there's always the story behind the story, and if that story's not before the court, it's not the court's business. Where it's brought to the court, I think Judge Rustani legitimately raised critical questions that have to be asked and answered. To a certain extent, it's in the eye of the beholder as to whether that's ultimately relevant. But for Judge Rustani, under the facts and circumstances of those cases, it was relevant.
The big red flag there being the petitioner for the administrative review, listed 200 plus respondents and then dropped it down after an amendment, right, to.
Yeah. And I think what happened in the Nails case, right, it's the order of magnitude, right? You started off with an enormous request of companies in the administrative review, and then it got shrunk down. And so, if you've got any kind of tingly antenna, they're going to start jingling, right? And you're going to be concerned. The question is, how far can you go as the court in that regard?
Thank you, Judge. Thank you very much. We have a 10-minute break, and
thank you all. I appreciate it greatly.
Our next panel will be on EBA issues and reverse false claim act actions. 10 minutes. So how was it?
The person who designed the four things were class of 87, and the person who implemented it was class of 87.
Holy, we have to bring them here.
I'm the one who designed it.
Man,
Who designed the cars.
I met him. Wow.
You don't have to mention it.
No, I won't say that, but it's good to. We have to be in touch, especially when the Fetzer decision comes out. We should have.
See what the,
And you know what? You can give away as prizes anything you want because we don't. I'm not taking them home.
really?
Okay. Put them all up right here.
Yeah.
Between everybody. So they're not handing the fact. Are they handing the fact?
So they said they put it up on the website is what they were doing. I didn't go and I could check to see if they had done that,
So
but I
what I might say if I were you is that this was the original petitioner. Just use this as
okay.
original
Yeah.
petitioners.
That's in scope, that's out of scope. Or that's
And
the
these two are, I mean, these are exactly the same except just size.
yeah.
You put them, one here, these two here.
Okay. Okay.
And whoever answers the question right can have it.
Yeah. Leave something up here. Was it on this?
Yeah, it was on that,
Was it open?
and they changed it out.
I think they changed it out, yeah. Okay.
So now the question is, because I don't want to take somebody's water bottle.
You can have mine, I'm not gonna drink mine.
Are you going to drink your coffee?
That's not my coffee, that's Nathan's.
So I protected the honor and integrity of the Justice Department making enforcement decisions
Yeah, keeping it.
about trials.
We keep keeping it.
Emily?
Good morning.
Hey,
How
good
are
morning.
you?
Great to see you.
Nice to see you.
How's everything?
Oh, good, good.
Your
Tea
trip
is
out
the
was-
gift that keeps on giving.
I'm sorry?
Tea is the gift that
Yes,
keeps on giving.
absolutely.
Easy trip for me though. Quick plane ride. I was in downtown last night. Their downtown is so quiet
Yeah.
compared to DC and certainly anything in New
Yeah.
York.
Did you go over by the waterfront area? And the,
I did. I took a quick walk, but it was getting dark, so I didn't have too much time before it started getting really cold.
So are you checking in on the customs office here?
I wish I had time. No, I would have loved to have come out sooner, but we have been so busy with
Everybody is. I mean, it just
drawback
doesn't.
lately.
Drawback. Interesting. Boy, it's amazing how things run in cycles.
Oh,
It's just
I have been living and breathing it
wow.
more than a year ago.
That's
So
interesting.
yeah, coming back to IPA is like it's a nice break for me.
Any particular sector that's more active in the drawback arena than
Well, I mean,
before?
it's niche, and so the customs brokers and consultants who work in drawback, they're very drawback focused.
I mean, sugar, orange juice.
Yeah, you certainly see sugar, orange juice, petroleum is big,
Right.
wine. You guys will be hearing
Wine.
about distilleries sometime soon if you don't know already. So those are big industries in it, but we've got a lot of different players, and I think we're going to see an expansion of that as soon as TIFTIA drawback.
I had a rice drawback case that was
Yes.
fascinating.
Yeah.
And it's kind of an example of the summer judgment issue.
Okay.
So it was two grades of rice. You know, A for B, B for A.
He did say
And I
that, yes.
said, it can't be decided by summer judgment. Because if you agree that A is substitutable for B,
You guys can go over this. For
For
members of this panel,
Right.
right? Case
Richard?
get settled.
Right.
And if
Good.
you have some members of this panel, then I'll give the other members.
And, you know, my
For you, then I
parties
need
kept maintaining, you know, summary judgment. I denied summary judgment the first time. And I said, okay, you think you can have some money. I sent them off. I said, go do. A month later, the case got dropped because they couldn't make it. I think
Yeah,
because they couldn't make it.
we settle out and we resolve a lot of that stuff eventually.
You must be Emily.
Hi, it's
Thank
very
you
nice
so
to
much
meet
for
you.
coming.
I'm Erica.
Your presence is a great thing to start with this panel, and so appreciate it.
Well, thank you, and I
A small gift for you,
well, thank you very
and
much.
for you, Judge. Maybe you should take this during lunch so we can exchange if
Yeah,
you
because
need it.
extra large is way too big for me, I can tell you that.
So Richard might like that.
So, Emily, this is my wife, Marcia. Emily Simon.
Very nice to meet you.
Emily, did you?
No, I didn't have a practice at the office, yeah, so we missed each other. But we sent them out. Well, I suspect you'll be hearing a lot more about drawback, and actually what we're going to do is make classification even more relevant in the future because it's basis for substitution. So get ready for more.
Well, they're up for grabs.
I think it's around 3, but I'm not 100% sure. I have to double check. I tried to leave a little bit of time after this panel to hang around because I didn't know what was going on.
Yeah.
Yeah, what about you?
I'm like at 5:30.
Okay, yeah, that's a little bit easier. I was trying to get home before bedtime. I was like, just do that.
Quick trip in, trip out.
Yeah. Well, and I wish I'd been able to stay at Wooden House because I think that was a lot more convenient.
They moved me like right, yeah, it's right across the street.
Yeah.
Look forward to it. Yeah, I'll put it too. What's up? Oh,
Gosh. Let's,
it's fine.
actually, let's see.
Does that work, or do you want to switch orders?
I think I can switch with you if you like.
Yeah, we can
Here you go.
switch signs.
Whatever you want to do.
There we go. Hi. Oh. How are you?
All right. Wait, am I in front of my right name?
Yeah, make sure everybody is in alignment. Unless somebody else wants to do the government part.
Well, you know, at least you go high tech. I'm like, this is like plain notes, you know,
This is just a
cutting and taping my little scraps.
That reminds me of my years in debate. Our debate
Pretty well. I see
someone
you're
set us
got a
up
great
something
panel
in
lineup
our
there.
argument.
You know, well, that's how we used
Yeah,
to do
well, I
it
was
when I
kind
was
of
in
sucked
law
in for a
school.
little bit, and then I was like, I've only got
Nice when I went
authorizations
to law
for
school
like,
here.
yeah. So are you in Kansas now?
They put in.
Oh, okay.
I went
Oh,
when I was in law school, like my
yeah, definitely.
second year. I put in this type of
Yeah,
smart
yeah, yeah.
classroom, and
Maybe we'll see.
all I remember were all the ideals that they
I went to Ohio State.
information you can get.
Yeah.
All people did was play
All right.
video games the entire
Yeah.
time, like right. But the other thing was, all the rooms in this building were so dark.
Good morning, everyone. We'll start our second panel for today, which will be discussing alternative trade remedies in the customs perspective, focusing on the Enforce and Protect Act of 2015. My name is Justin Miller. I'm a senior trial counsel with the Department of Justice. And as with Judge Gordon, I give the general disclaimer that these remarks today are my own and do not represent the views of the department. And with me today, to my immediate right, is Emily Simon. She's an attorney with the Entry Process and Duty Refunds branch of the Office of Regulations and Rulings for U.S. Customs and Border Protection in Washington, D.C. To her right is Nathaniel Rickard, a partner from Picard, Kentz, and Rowe. And to our farthest right is Mr. Richard Wortman, a partner with Grunfeld, Desiderio, Leibowitz, Silverman, and Claystad out of the Los Angeles office. So today we're going to be discussing EPA, a statute that came into effect a little over a year ago. And as we heard earlier from Judge Gordon, there's been an increased focus on targeting enforcement actions generally within the United States, but with respect to the EPA, it's targeting duty evasion. Duty evasion has been of particular concern for the trade community for a number of years, and the statute upon which EPA was based had been debated for a number of years as well, and it wasn't until last year that it was successfully passed and enacted. So today, as we discuss the parameters of EPA, we have a hypothetical factual situation to provide a little bit more context. And our hypothetical will focus on these cups that you see here before you today, sippy cups. And under our hypothetical, there is an anti-dumping duty order in place for extruded and or molded plastic cups. So those would be the ones at the far right of the podium. These items would be were brought by a petitioner for an anti-dumping duty order, and they are within scope order, and they receive up to 200% in anti-dumping duties. You have a separate manufacturer of the sippy cups. They're bringing them into the United States. On their import papers, they describe them as plastic children's cups. A question arose as to whether these items should be subject to the order. The importer revised its entry papers and described the merchandise as sippy cups. Suddenly, then, it triggered an investigation by the U.S. Customs and Border Protection as to whether there has been an invasion of duties, an invasion of the order. And as we discuss further what the parameters of the EPA are, we can use these items as a useful example in discussing exactly what evasion is and what are some of the concerns and issues that both foreign manufacturers and importers and domestic industries consider when they decide that they want to pursue relief under the EPA. So with that, I'm going to turn it to Emily, who will give us an overview of the statute.
So, good morning, and thank you for having us here today. Again, same disclaimer, the remarks that I will make today are my own and do not represent those of U.S. Customs and Border Protection, and all remarks should be considered off the record. So with that said, let's talk about not just this scenario with regard to what does or doesn't constitute a sippy cup under the scope of an anti-dumping order, but I want to situate this a little bit more generally for you in terms of how AD/CVD enforcement works. So as many of you know, the Department of Commerce and the International Trade Commission are responsible for the AD/CVD orders and setting the rates that apply. Customs' role in this process is what we refer to as a ministerial role. We do not decide the story behind the story, if you will, as Judge Gordon referred to, as to what is or what is not within scope of an anti-dumping order, but we are responsible for its enforcement. That is sometimes a very straightforward endeavor, and sometimes it is not for Customs and Border Protection. So when we talk about EPA, the Enforce and Protect Act, it was introduced to help CBP facilitate the process of AD/CVD enforcement. That is not to say that we did not have AD/CVD enforcement prior to EPA, simply that the mechanisms made available to us did not exist. And the reason for that is because we are a law enforcement agency. Generally in our proceedings, we do not engage with the public when we are pursuing a potential evader of AD/CVD. There are certain confidentiality concerns and other aspects of law enforcement investigations that would preclude that on an ordinary level. However, EPA changed the landscape by allowing other parties to engage with CBP in an effort to enforce AD/CVD orders. So obviously, from the perspective of domestic industry and the petitioners who pursue the AD/CVD orders, this was an important option to make available to them. Why the frustration? Well, one of the common criticisms of CBP for AD/CVD enforcement is that we move too slow and we often aren't in a position to collect, if you will, the additional duties that are owed by the time we determine that there's been evasion. So we move forward with EPA in a way that should speed up investigations and allow the trade to participate when they have knowledge. E-Allegations is a CBP website that allows the public to bring to CBP's attention on an anonymous basis concerns, if they wish it to be anonymous, you certainly could identify yourself, but concerns about any kind of trade violation, including AD/CVD. Before EPA, that was the way in which the public could provide to CBP tips about evasion. EPA created a more structured process where the black box, which is what E-Allegations was referred to by a lot of the AD/CVD petitioners, was no longer a black box, but now an opportunity for a more transparent process. So within 180 days after the Trade Facilitation and Trade Enforcement Act was passed, CBP had to promulgate regulations. And that's a huge endeavor for any administrative agency. What we did was we issued an interim final rule. so that the rule became effective immediately and the agency collected comments. And in the future, we will issue a final rule based on our experiences up to that point with respect to EPA enforcement. So the interim final rule came out, and it took what Congress provided to us under EPA and created a much more significant framework with timeframes, notice requirements, and all of the other sort of regulations that you would need in order to have this kind of process. So this process, while it might seem kind of like some of the other processes you see in the Department of Commerce and the International Trade Commission, it is not exactly that. It does involve public engagement, but we don't operate under administrative protective orders and those sorts of mechanisms that make it a much more involved process when the orders are actually being issued and the rates are being set. So what EPA did was it gave us essentially a 1-year time period, and I'm sort of rounding, for investigations to take place. It requires the agency to provide technical assistance to small businesses that might wish to engage. So if, for example, a small business that may be domestically manufactured some kind of product similar to some of these other things that you see up here became frustrated because they thought that these sippy cups are being imported with a lower rate of duty and should be subject to AD/CVD. If they had concerns about those sippy cups, they could come to CBP in advance, where we would provide technical assistance to them. That's one of the things EPA did, again, in the spirit of being facilitative in this process. Now, what happens generally in an EPA investigation is that certain members of the public have the right to file with us an allegation. These interested parties submit to CBP electronically on the eAllegations website by selecting the specific option for EPA, an allegation that establishes certain criteria that we require in order to move forward with an AD/CVD investigation under EPA. And evasion here in this context simply refers to bringing goods into the country that should be subject to AD/CVD at a specific rate and either paying a different rate or no rate at all, so that you could engage in evasion by giving us false case numbers, maybe for lower rates, or no case numbers at all. Oftentimes, there are misclassifications involved when you're looking at evasion type scenario, so that CBP may not be as aware of what you're doing. And I want to stop right here and point out that when you are in this sort of situation as an importer, classification is not dispositive with respect to the scope of anti-dumping and countervailing duty orders, but it is often an indicator or a flag for CBP that if a specific HTS provision is called out in an order, of course we're looking for that on importation. So a very common form of evasion is going to be misclassifying goods under a provision that's not called out in an order. So that's worth noting. And if you look at the fact pattern that you have, I also can't help but point out as a customs attorney that deferring to your broker for classification can often be a dangerous endeavor. And so one thing that importers should be careful of is always to engage in reasonable care when classifying their goods. And again, broker deference, especially without providing brokers all the facts regarding what goods are. When it comes to AD/CVD orders, that importer of record is still on the hook for the anti-dumping and countervailing duty liability. And at the end of the day, even though I think a prior disclosure was hinted at in the fact pattern, you are always liable for the AD/CVD that would apply to your goods, even if you didn't know you brought them in. Now, it's worth pointing out that for EPA investigation purposes, if you didn't know because of a clerical error that your goods were subject, or that's why you didn't report them as being subject, you would not be within the scope of an EPA investigation. That's carved out by the EPA statute. However, you would again still be liable for the payment of the AD/CVD duties. So with that in mind, once an EPA allegation is filed, and it must identify not only the party that's making the allegation, but the party against whom the allegation is brought, the AD/CVD orders in issue, and the nature of what is believed to be the act of evasion. And an EPA allegation has to be based on information that is reasonably available to the party that brings it. So we can't, for example, expect a party to have access to trade data that is confidential or proprietary, but we would expect certain information to be contained in those allegations. And I think some of the other panelists are going to touch on what CBP has and has not been allowing in this context. But CBP has a 15-day window from the time of receipt of an allegation to make its determination as to whether or not the agency is going to investigate. And we have attempted to be quite transparent in this process. If you go to the CBP website, we do make available the checklist we use to ensure that an EPA allegation at the time of receipt is complete, as well as the checklist that we use to determine whether or not it reasonably suggests that there is, in fact, evasion going on. And CBP has also made efforts, and I will leave that to the other panelists to discuss, to be transparent with respect to those cases where it has decided to move forward with the investigations. So that is really the genesis of where the EPA process starts. And we have the initiation, of course, followed by investigation, and then appeals. And the way that this panel is structured is we'll touch upon the next two phases, both the investigation and appeals, during the course of our discussion. So we'll talk about that in a little bit more detail as we move on. I know Justin has some questions for this particular phase, but I want to point out that the investigation that is begun at this process, and there's a 300-day time frame for the investigation to be conducted, or 60 additional days, up to 360 for an extraordinarily complex type of case. We have to make our determination within that window, which arguably is a lot shorter than the sort of substantial investigations that are conducted without notice to the public regarding AD/CVD violations. So that really kicks off the process. The investigations are conducted. They're led by CBP's Office of Trade within the Trade Remedy Law Enforcement Directorate, which is one of 5 directorates in the Office of Trade. But they work not only within that directorate, which oversees the investigation, but with the assistance of auditors and the folks in the field. So in the hypothetical scenario that we have, if you have a request for information that comes in asking about AD/CVD type situations, that may, but does not necessarily mean, that you could be subject to an EPA investigation. So I want to point that out. It's a red flag, certainly for any importer, anytime CBP possibly suggests that you could be subject to AD/CVD.
Thanks, Emily. I think it would be provide good context if I read what the actual statutory definition of evasion is in this context. And the statute defines evasion as entering merchandise by means of any document or electronically transmitted data or information, written or oral statement, or act that is material and false, or any omission that is material and that results in any cash deposit or other security or any amount of applicable anti-dumping or countervailing duties being reduced or not being applied with respect to the merchandise. That's an interesting definition. Emily, would you like to speak to what that means?
Well, it's not just what it means, but what I think it doesn't mean in this context that's important. You don't have to intend to actually evade. There doesn't have to be the same level of culpability that you would expect in a 1592 investigation for negligence, gross negligence, or fraud. This is simply the act of evasion and what you may have done to contribute in that regard. And I think you're going to see importers, and that's certainly the target of EPA, being pursued on that front.
Thanks. Nathan, who are bringing allegations? Who are the entities that we are seeing are filing allegations under the EPA?
So under the current, with a year of experience, what CBP has seen so far is EPA allegations filed by domestic industries, domestic producers. But what makes EPA interesting in the trade field, I think, and it goes to kind of what Richard's going to be talking about, is there isn't a lot of opportunities for foreign exporters and U.S. importers to get involved formally in proceedings about enforcement of trade remedies. And quite often, the U.S. importers and foreign exporters may have as much of an interest in enforcement on the trade remedies as do the domestic producers. And so EPA, as a statute, permits both importers and foreign producers to also file EPA allegations, which is not something that they can really participate in at the commerce level of trying to get increased enforcement.
but they will have that opportunity within EPA, and we'll see whether or not that is something else that there are more allegations coming from those parts of the trade community.
Thanks. Richard, speak to us a little bit about notice. When will the party who is subject of an invasion allegation receive notice?
Well, at least in theory, under the EPA timetable, there's going to be at least a 60-day period which there's going to be radio silence. Having said that, this week, an EPA case was made public to a company called American Pacific Rubber. And I just want to pull out the relevant dates from this case as it's stated in the public version. So the domestic manufacturer filed a complaint on June 21st. On July 18th, Customs initiated a review. And on October 23rd, the case was made public. From a practitioner's point of view, I should say that one of the biggest problems that we see in this case using EPA is that a broker and or an importer may not know that they or their client is under investigation. And what happens during that period is that Customs is often out looking for information. And one of the ways they do that is they issue what are known as Customs Forms 28 and 29, requests for information. And using those forms, they're asking for lots of information. I will tell you from the practice, the day-to-day practice of customs law, most of those are responded to in a slipshod manner, especially by brokers and importers who just kind of say, here's a pile of papers, take them. And unfortunately, you don't know that whether or not you're under investigation. And one of the messages, as a practitioner, we've been trying to tell our broker clients, as well as our importer clients, is if you are importing merchandise that is subject to a dumping order, you really have to take these requests very seriously. You really need to engage counsel sooner rather than later. The worst that happens is you're not under investigation. But as a practical matter, often if you get a very serious request, more than something out of the ordinary, please provide us document X, that should be a red flag.
Richard, you mentioned something in our preparations for this panel today that I thought was rather interesting. You indicated that when people receive, or when importers receive these Form 28s, they should operate under the presumption that they're under an investigation until they've received notice that they're not.
Absolutely. We represent clients that run the gamut of products. And some of these orders have been out there. There are orders that predate my beginning in this practice 30 years ago. I mean, these orders have very long lives, many of them. And so you have to assume that if you get a request for information on a product that's subject to a particular dumping order, that you should assume that you're under investigation. And I think that prudence would dictate that.
Nathan, it looks like from the regulations that the record will be limited to submissions by the interested parties. If you're representing a third party out there in the trade community and has information that's relevant to this investigation, what would you counsel that party in terms of providing that information to the agency?
Well, the record can include anything that Customs wants. They have a lot of discretion to go out and get anything that they need to. And I think the concern within the trade community is if you do have that information, how do you best participate? And for practitioners and parties that are outside of it that are interested in these cases, interested in enforcement, what's key is the publication by CBP. And there is nothing in the statute or the regulations that obligates CBP to publish stuff. So now we're seeing these notices of action going out. When they go out, that is the way that the trade community is going to be informed that something is going forward. And then you have the time from the notice that the investigation has been initiated to go in and participate if you so choose. And then you can submit things to Customs, to the Trade Remedy Law Enforcement Directorate that you think would be relevant to their review. But what's essential then is that CBP give adequate notice out and timely notice out to the community to get that assistance. And in one of the cases that's happened so far, there was a pretty long delay in notice going out. The concerns that because it's not something that's obligated, Customs could decide that they weren't going to publish things. And in that case, there is no opportunity for other parties to opine on what the case is going forward.
Emily?
Yeah, so the parties that are parties to the investigation, which is a term that's defined under the regulations, are the party or parties that bring forth the allegation of evasion and the party or parties against whom the allegation is brought. There is a mechanism for CBP to allow other parties to participate in the process, both in terms of the collection of information, but also in terms of consolidating investigations. So it is possible for an entity that's not initially a party to an investigation to become one by submitting an allegation after they become aware of an earlier one. And CBP then has the authority to consolidate for purposes of administrative efficiency those investigations, and then that gives the entity that stepped in as a party after the original party filed the allegation the ability to fully participate within the context of the EPA process. That's something to be aware of. Consolidation is discretionary, but often in the best interest of the agency. But when it does happen, we are held to the original timelines that are triggered by the first filed allegation. And just quickly, I wanted to point out an important benchmark in this process. We have 15 days from the day that the allegation is filed to decide whether to investigate. But then we have an additional 90 days after the point that we make our decision, where CBP, by the 90th day, has to make a decision as to whether to impose interim measures. CBP made the determination, because the statute did not, that the appropriate point in time to provide the alleged evader notice of the ongoing investigation was no later than 5 days after the imposition of interim measures. We can wait until the 90th day, which means by the 95th day of the investigation, we have to give notice to the alleged evader, or if we impose interim measures maybe 30 days in, then we would give notice 5 days later to the alleged evader. That 90-day window is an opportunity for CBP to conduct its investigation without providing notice of the official investigation to the alleged evader. Why is that important? Because sometimes it's easier to solicit and obtain additional information before a party knows it's under investigation. So that 90-day time frame, should we choose to maximize it, is available, but it certainly is not the case that we would maximize it in all instances. And interim measures are an important point in this process, because that's when CBP will extend or suspend the liquidation of import entries that could be subject, and it will also, at that point, require the collection of the additional duties that could be owed. So it's here, financially, that things get heated for the alleged evader, not at the end of the investigation, but at the imposition of those interim measures. Should we determine, and this is the standard, that there is reasonable suspicion that evasion is ongoing. So CBP has to use that reasonable suspicion standard no later than 90 days into the investigation to decide whether to collect additional duties that could be owed on the import entries that are, for which liquidation is not final. So that's an important, I think, factor to be aware of in this process, because certainly from the perspective of the party making the allegation, this is the pressure that they want to put to enforce those AD/CVD orders.
With this framework in mind, Nate, would you like to give us a summary of what EPA proceedings have been filed over the past year, and maybe what are some of the concerns that have been expressed by the domestic manufacturers who are pursuing relief under the statute?
Sure. I just start off with stepping back as to why we are here. The AD/CVD laws are pursued as remedies for unfair trade by domestic industries that believe that they need stuff to counteract unfair trade in order to survive. And I've been practicing about 20 years. I think in the beginning of my practice, there was an assumption that once you get an anti-dumping duty order or a countervailing duty order, the trade remedy is in place. And what we have learned with more information as people have gone through and had experience with their cases is that assumption is not warranted. The GAO has issued a report recently where they found that only 31% of the amount of duties assessed was on anti-dumping and countervailing duties was actually collected. You can look on an annual basis from what Customs is reporting to Congress that they are now making public, what are just some absurd factual circumstances where there are huge amounts of merchandise coming into the United States, where the general tariff, the anti-dumping duty rate would be in the triple digits, and yet there's nothing being deposited on those imports that are going in. So EPA is a response to that. It is a way of trying to get more involved on enforcement and to try and see if the AD/CVD stuff can work. And that means that EPA is really focused on how you make the orders work. It is entirely complementary, and it is different than perhaps other ways that you might deal with evasion and circumvention, because what you're really looking at is what can I do to make it so that there is a market impact from these trade remedies in place. So 1 year of experience for CBP. There have been public notices out about 15 investigations. Of the 15, 14 of them have resulted in interim measures. One was not initiated. They have covered 3 areas of evasion that's been confronted in the marketplace. The most of them have dealt with transshipment. That has led Customs to do overseas visits to factories and facilities where there were supposedly things being produced. And what they've found is consistent with what the domestic industries have been complaining about, is that quite often there are addresses used or pass-through entities used in other countries that do not actually manufacture anything. And the reports that CBP has issued so far of their site visits have been very helpful in kind of understanding how this operates. The second thing that they have been looking into in these EPA investigations is just straight misclassification, where a product is classified as something not subject to anti-dumping duties, when in fact it is concealing what the product actually is. The third has been, and this is sort of mixed right now, but there's one case where the agency is looking into, in the context of wooden bedroom furniture, the potential use of a foreign exporter that had a lower cash deposit rate than who actually manufactured it. So it usually is called deposit rate borrowing, or you're assuming the identity of somebody else. So that's the sort of the overview of cases. One of the things that's coming out of it is the different challenges that CBP faces in its evidentiary standards. The easiest seems to be misclassification, that what you're getting there is an ability for CBP to pop containers open and look at merchandise and to see whether or not that is actually classified correctly. When a container has been popped, that is something that they can look at and make a factual determination and say that we believe that this should have been the scope, that it was misclassified. On transshipment, on use of other anti-dump deposit rates, that is much more difficult for Customs, and that will be something that I think will be presenting a challenge to the agency over time about how well they'll be able to sustain those determinations and how complicated it will be for them to conduct those investigations. Right now, on transshipment in particular, it's been easy because you go to a facility and there's literally nothing there. So that's been the sort of first part of it. I think it'll get more complicated as people continue to file these allegations.
Richard, let's discuss scope for a moment. The statute provides a mechanism by which Customs can refer a matter to Commerce if there is a question as to whether the good falls within the scope of an order. And I think the sippy cup hypothetical is a great example of this. What do you see out there in the trade community, in the practical world, in terms of how often these scope issues are arising, and what would you counsel a client when they come to you and there is this question of scope?
All right, so let's talk reality here before we even get to EPA. Let's say we have the sippy cup, and we don't know if it is subject to the anti-dumping order or not. At the agency level, the import specialist will say, go to Commerce and get a ruling. We can't make a decision. And most, without the authority of the agency, will also tell you, probably, we're going to assume it's in the case unless it's not, so we're going to collect the duties because nobody has ever fired us for saying no. But if we say yes, we can get into a lot of trouble. So the biggest problem is if you send this to the agency, to the Commerce Department for a scope ruling, a scope ruling should take, statutorily, somewhere around 60 to 90 days. In fact, we're running on average of 1 year. So, if tomorrow there were an allegation about the sippy cups and the allegations were raised, yet there's no scope determination out there, I think Customs would be very, very hard-pressed to begin an EPA investigation without having a foundation to begin with. And the foundation is a scope ruling that says, yes, you're in, or no, you're not in. So I think that in real-life terms, we have a lot of challenges on a day-to-day basis on merchandise that may or may not be within the scope. But as to EPA, it's going to be I think it would be very hard, and Emily can comment, further address this, but I think that they would probably, I would guess, and I would hope that if the scope is up in the air, then I would hope that an EPA allegation would die of its own weight after 60 or 90 days.
Emily, would you like to speak to that?
So as I pointed out in the beginning, scope is a difficult issue for Customs because of our ministerial function. We're not involved in the ADCVD initial determinations by the DOC and by the ITC. And so we have, under the EPA, the statutory right to make a referral to the Department of Commerce during our processes. Now, the statute itself does not specify when CBP can or cannot make the referrals. We believe that the referrals can be made anytime up until the investigation reaches its deadline of either 300 or, in extraordinarily complicated cases, 360 days. Now, I just told you 300 or 360 days, but if we go to the Department of Commerce, that effectively stays the investigation, so that those timelines that are supposed to run under the statute are stopped until we have a response from the Department of Commerce. What's the effect? Well, I think you just heard how long it can take right now in public-facing determinations for Commerce to make its decisions. Now, whether Commerce has to follow the exact procedures it does in public-facing investigations, I don't know that we have the final word on that yet. But Commerce does have to make some sort of determination, which can be a time-consuming process. So it is entirely possible that before we reach the deadline for the imposition of, let's say, interim measures, we could reach out to the Department of Commerce for their input, which could then turn that 90-day period that somebody against whom an allegation has been brought would typically expect to hear within 5 days afterwards about whether they are in fact the subject of investigation into a much longer period of time. So it is something to be aware of. Certainly from the standpoint of a potential evader, wanting the input of the Department of Commerce could be potentially helpful, especially before the imposition of interim measures, where that's when you get that financial impact, if you will, that big issue for anybody against whom an allegation of evasion is brought. So I think understanding that there is a role here for the Department of Commerce, should Customs choose to reach out to them, is critical. And then just keep in mind that whether there's an EPA investigation going on or not, the agencies are able to communicate with each other when there are scope issues, and the levels of that communication can vary depending on the type of investigation that is ongoing.
I just add to that there's a practical implication of this. And when we're talking about allegations, or what launches EPA, I left out the fact that the government agencies can also make referrals. But if we just stick on private parties making an EPA allegation, if it's coming from a domestic industry, it's because it's a concern regarding those imports, which means that the industry believes that it is within scope, that they intended the trade remedy to cover that merchandise that's coming in. if you've gotten to a point where it's not clear that whether it's in or outside of scope, EPA is probably a really bad place to try and litigate that through, because it will get lost in the referral to Commerce. And so that should be a natural check on how much of a problem this will be. As a practical matter, if you're looking at these sippy cups and you are concerned with your ability to sell into a marketplace where this merchandise is coming in, and you filed an EPA allegation, you're likely doing that because you have seen in the trade data, in stuff that you're going, or with customers, that you can confirm with bill of lading data from private subscription services, that there's actually imports that are coming in. And what you mirror that with, or what you check that against, is the admin review process. And so when we talk about the story behind the story, one of the reasons why domestic industries make admin review requests that cover hundreds of exporters as a routine matter in cases is because it is the only way you can ever get to look at type 3 data from CBP. What is being announced or declared at importation as subject to AD/CVD. Under the administrative protective orders that Commerce issues, you put in your request, Commerce makes a request to Customs as to the type 3 entries that are related to those exporters. And what you can learn from that, or what I constantly learn, is that most of the stuff that we're concerned about is not being entered as type 3. And we will take that and go back to Customs, whether in EPA or in a different format, and say, we need you to look at this merchandise because we think that this stuff should have been subject and scope. And the indications are that it's not. And we will also then make withdrawals on the admin review requests of stuff that didn't get declared as type 3, usually at the request of Commerce, just to make it cleaner and easier for those admin reviews to be rescinded. So all of this stuff kind of plays together in different ways, and we again want to make it so that we're really just focused on the merchandise that you think is coming in that's having a harmful impact in the marketplace on your domestic industry clients. Sure. Well, do you want to do it?
Happy to do it. Customs has different entry types that are made when goods are brought into the country. The most common entry type is the type 01, which is an entry for consumption. However, if your goods have AD/CVD duties associated with them, you have to make a type 03 entry. That tells Customs that you're identifying an AD/CVD order or orders on your import entry and depositing the money at the rate that is believed to be applicable, although not final, at the time that the goods are entered. So those type 03 entries are telling Customs up front that you've paid your duties, and from an evasion standpoint, maybe you've identified the wrong case. That's a potential concern. But the type 01 entries are where you're going to have your misclassification errors in a AD/CVD evasion type context. So those would provide the HTS codes, just like all entries do, but they wouldn't usually identify an HTS code associated with an AD/CVD order in an attempt to sometimes evade having to make those deposits, which again are very hefty deposits that have to be made under those orders.
Our duty assessment system for anti-dumping and countervailing duties overall is tied completely to the type 3 entries. The statutory injunction is injunctions on type 3 entries. The Commerce Department's admin reviews are reviews of type 3 entries. And so the easiest way to opt out of all of this is just to declare something as not type 3, and then it presents all the challenges that EPA is trying to get to in enforcement.
Of course, if interim measures are imposed, we collect those deposits, and your entries, if made as type 01s, would be converted to type 03s at that time.
I think one last thing that we should add to this, for those who don't do this on a daily basis, is that when entries are brought in, duties that are paid are estimates. In the case of type 01 entries, goods that are going to be consumed, there is a procedural mechanism to liquidate them or make them final within 315 days. For 03 entries, they are open-ended and can live for many lifetimes. So it is possible, we've seen many cases where anti-dumping duties, a deposit may have been done at 12%, and 7, 10, 12 years down the road, anti-dumping duties could be finalized at 250%. So the transactions are not complete, they're open, and they go on for years. and in fact can put people out of business many years later without even their knowledge that this is going on.
Yeah, and this has a very practical, again, impact on the way that you think about enforcement of AD/CVD orders. If customs is tied to when you actually collect on assessments, that can take a long time, well after the imports have come in. What EPA allows through interim measures is to be able to have a market impact rather quickly, that you're talking about whether or not you're paying the cash deposits, not necessarily assessments. In their discussion, Judge Gordon and Professor Colares talked a little bit about Rupari. You know, there is a 2015 case that was before the Federal Circuit, sort of went through the facts of Rupari. Rupari is about crawfish tail meat transshipment through Thailand that occurred in 1998. And that's, you know, that's the calendar that you're looking at when you're talking about enforcement sort of through the traditional stuff, well after whether there's going to be a market impact or not. EPA gets you to those points of having, requiring cash deposits on entries sort of very, very quickly after the behavior is identified and the investigation is initiated.
So with these complexities in mind, Richard, why don't you discuss with us a little bit about what alternatives are there to the EPA? What other statutory mechanisms exist if a domestic manufacturer wished to further pursue enforcement matters?
All right. So I'm going to talk to this as a practitioner, as a day-to-day practitioner who represents importers, who represents customs brokers. And I think that the way to talk this through is start by how do one of these cases get started? We heard already that the government may initiate their own case. But there are other ways that these cases get started. Competitors can bring an EPA allegation. And finally, my personal favorite one is what we call in our office the former employee rats you out case. So we see those not just in the anti-dumping context, actually, we see them in many different cases. But I think that in that context, TIFTIA, when it was implemented, the interim regulations went into effect in August of 16. The very last regulation on the list. I'm sorry? Are you talking about the Trade Facilitation Trade Act? Yes. Which then led to EPA. The last regulation, 19 CFR 165.47, essentially says that nothing in EPA precludes any other remedy at law, equity, or anything else anybody can cobble together. So the real question is, what are the other remedies? So there are essentially two different things to look at. Now, Judge Gordon earlier today mentioned 19 U.S.C. 1592. 19 U.S.C. 1592 is, for lack of a better description, it's your general purpose negligence, gross negligence, fraud, for whether omission or commission. It's penalties for pretty much anything under the customs law. And in addition, there is the False Claims Act, which I'll get to in a minute. So in 1592, you have a material misstatement which is made, and the potential penalties to the importer run from negligence from up to 2 times the loss of revenue all the way to fraud to up to 8 times the loss of revenue. So quite a possible point. Now, at this point, the question is, why would we use that as a mechanism? Now, I will tell you, up until the creation of EPA, the way that we often got relief in these cases where we represented one importer who was following the rules and we were trying to stop somebody, is we would go to a friendly auditor, investigator, branch chief at Customs and say, we've got this person, they're doing all these things, and here, by the way, are 6 loose leaves of documents telling you exactly what they've done. Now, under 1592, if you rat someone out, there is actually the potential for a financial reward. That financial reward is called a moiety. Now, a moiety is a misnomer. I will tell you that in this room, although in its earlier incarnation, when I studied Admiralty in this very room 30 years ago, I was told that a moiety is 50% of whatever you recover. Well, the statute doesn't allow, a moiety is not 50% under the customs statute. It actually, 19 U.S.C. 1619, it says that the recovery should not exceed 25% up to $250,000. So that was one reason to go. A, you could collect some, you might be able to make some money, but 2, you could get Customs to help you stop bad behavior. The problem with 1592 was there was no transparency to the person who outlaid the claim. If we went to an agent, I mean, maybe they might tell us they've taken some action, but generally, until we saw it happening in the marketplace, we really didn't know what happened. There was no transparency. And often in cases with 1592, when we were looking for a moiety, when the client was looking for a moiety, there was also there was always a struggle about whether or not they deserved to be rewarded for ratting someone out, and did they tell somebody information that was already in Customs' hands, and so forth. But in the last 20 years, since the mid-'80s, probably the most popular method was under the False Claims Act. So just by way of history, the False Claims Act was created during the Civil War so that subcontractors wouldn't sell bad bullets to the North so that they could make sure that they actually really killed the soldiers from the South. That was why the False Claims Act was created. Today, so in 1986, the government, Congress enacted some revisions to the False Claims Act, which allowed for what are called reverse false claims. Reverse false claims are where you tell something to the government and it causes the government to lose money. It's not that the government has gone out and spent bad money, but the government is losing money. And the government has, under this, can get monetary penalties, and probably the biggest monetary penalty besides the loss of revenue that they collected was that for each claim, so some people say it's per each entry, some people say it's each line of each entry, $11,000 per claim the government could collect, plus attorney's fees, plus costs. Now, the False Claims Act used in all the cases that were described before, whether it was classification, whether it was by saying it was from shipper A rather than shipper B. But the False Claims Act, the long and short of it is that any private party could act as in the shoes of the government and file this case. It had to be done under seal, and the Department of Justice had the right to, within 60 days, determine if they were going to take these cases on or not take these cases on. Let me say, as an aside, that early on, the Department of Justice was very anxious to take these cases on because they were great moneymakers for the Department of Justice. In the past several years, you could go to the Department of Justice with, evidence, absolute slam bang case, and the assistant U.S. attorney says, look, I don't have time for this, you go do it yourself. Now, remember, we talked about a moiety in the 1592 case. Well, under the False Claims Act, if the government decides to act for you, which is the best of all possible worlds, because then you start the case, and then you have the force of the U.S. government taking over the case, you still get 15 to 25% of the money. If the government decides not to take the case, you actually can get up to 25%, and there's no cap on it. So in a case, not an anti-dumping case, but in a recent case that had to do, it was about the valuation of merchandise by a little company that probably a quarter of you in this room will know because you have their product, a company called Otterbox. Otterbox had an employee went to management and said, we think you're undervaluing the merchandise because the merchandise, you're not including all of the value. And what happened was management said, go away, you're going to cost us money. And she went to management several times, and finally management had enough of her and quit. Remember I told you there was the former employee rat? She was the former employee rat. What happened was the case proceeded. There was a penalty case that went on simultaneously. And the Otterbox case was settled. Now that was the good news and the bad news. It was good news for the person who brought the case because she got a reward of $8.2 million for ratting out Otterbox. The bad news was that there were certain issues that never really got decided. And Otterbox was a case of first impression in one principle, and that principle was under what is known as the public disclosure bar. If Customs already knew about a problem, you can't collect on it in a False Claims Act case. And because Otterbox was settled with no guilt, despite the fact that she collected $8 million, we don't really know what the law is. The law is still kind of open about whether or not that bar really exists. The other thing that I will mention is the jurisdiction of the courts. Today we talked a lot about the Court of International Trade. What I will not talk about is the tortured history of all the cases that went through the CIT, and in the end, jurisdiction is in the local district courts. I'm just going to leave it at that because it was kind of a painful process for both the judges and the bar, because the bar and the judges, I don't want to speak for the judges of the court, but I would say that the bar really wanted these cases in the Court of International Trade. They felt that the Court of International Trade understood the imports and really understood it. Unfortunately, after going back and forth between the district court and the CIT, jurisdiction is in the Court of International Trade. I'm sorry, in the district court, not in the Court of International Trade. So the last issue that kind of comes up in all these cases, I alluded to in the Otterbox case, is what happens if the importer does make a prior disclosure sometime right before the person goes and makes any kind of allegation, whether we're talking about EPA, whether we're talking about whether we're talking about the False Claims Act. Prior disclosure is part of the same statutory framework of 1592, which essentially says, in short, mea culpa, I have sinned, here's how much I've sinned, here's where I've sinned, here's the money, and it stops the clock from running on any potential penalty. Remember, I told you the penalties were under 1592, 2 to 8 times the loss of revenue. The penalties then get locked in at interest on the money you owed for negligence and gross negligence, and for fraud, which frankly, I don't know that I've ever seen a fraud prior disclosure ever that's worked its way through, but if it were, at least in theory, it would be 2 times the loss of revenue plus interest. The question is, and this again is an open question, is a prior disclosure still available? That question has not been touched yet. I am guessing over the course of the next year or two, somewhere along the line in an EPA investigation, someone is going to raise the flag. I've already disclosed this. Why are you making this case? And that's going to work its way. The prior disclosure piece will work its way through the Court of International Trade.
So with that, let's take some questions from the audience. We have about 5 minutes left here. Let's see if anybody has. Bo.
Just one quick comment, Richard. I'm proud to note that Otterbox did get that back in more by winning a customs classification case at the CIT. Proper classification of phone cases. So they took a hit there, but prevailed on a bigger customs issue.
Oh, absolutely.
Any other questions? Yes, over here.
Yeah, quick question. First is, when Customs does refer a scope determination to Commerce in the course of an EPA case, when might the party that the scope, the importer, be able to appeal that? Would that appeal go on simultaneously with the EPA case, or would that be separate? Then for Justin, with the absence of an administrative protective order, how is defending these cases, how is that going to be different for you at the court?
I'll have Emily go first, and then we'll talk about that.
Okay, so if the Department of Commerce makes a determination with respect to an EPA proceeding, at that point CBP would act on the determination from Commerce. So let's say they did say that the sippy cups were within scope. We resume our investigation. The 300 or 360-day timeline applies. We make our decision. It seems entirely possible that the decision by the Department of Commerce could be challenged within that time period. Whether or not that challenge would stay the EPA investigation, I think, is an open question. It is possible that if there is no final resolution on that Department of Commerce determination, if they've told Customs that it is within scope, we would proceed with our investigation. And it could, in fact, be the foundation for a final determination that the goods are, in fact, subject, and that CBP will proceed with its EPA investigation finding, which would be affirmative as to the violation. And at that point, there would be a window for an administrative appeal. So potentially you could raise those issues in the administrative appeal. Otherwise, whether the appeal is done and there's a certain amount of time after that or not, at some point that EPA determination will become final, and in order to disturb it, I think you would have to move into the courts to rectify things if down the line that Department of Commerce determination was in fact found to be incorrect. But again, these are open questions with regard to how EPA investigations will be handled.
You're actually challenging the scope, so how would you prevent liquidation of those entries in the meantime?
Well, I think that there are opportunities available to seek injunctions and other sorts of restraint with regard to the liquidation of entries if in case it's contemplated that there's an issue down the line. It hasn't played out yet, but I would imagine that you would want to stop Customs from making those liquidations final, notwithstanding the determination in the EPA investigation.
In terms of protection of business proprietary information, the court, through the court's Rules Advisory Committee, is currently discussing a format for transmitting BPI from the agency to the court. Some of the items that they've discussed is something similar to what we would see in an AD or CVD proceeding. If that framework is ultimately adopted, I think we're going to see something similar to what we do see in our trade cases. We have not had an EPA case yet have been appealed to the court, so it's yet to be tested. I mean, we could always protect the information through a judicial protective order that the parties will negotiate at the outset of the case, but they're hoping to streamline the process somewhat akin to the trade format. Any other questions? Yes, right.
Like Richard, I represent importers. Hearing the definition of evasion, it seems difficult to draw the line between negligence under 1592 and evasion that would launch a CBP investigation. Many of these importers of sippy cups and lots of other stuff tend to be small companies that might make a misclassification, that they may make an honest error or their broker makes that error. And I'm concerned about the delay in notification, that 90-day period that we were talking about. Wouldn't it be a better policy to give notice as soon as there was sufficient information to determine that this is a misclassification error as opposed to an actual evasion where the goods are misdescribed or something like that?
So a couple of points on that, and I think that does happen. There are importers, mom and pop shops that make mistakes in certain situations and maybe don't have the level of culpability that a sophisticated importer would. But with respect to first the definition of evasion, there is no element about mens rea. We don't require negligence, gross negligence, fraud. We don't even require intent to invade. It simply is that you either did not pay the AD/CVD that was owed or you paid the wrong rate. It's really a factual determination under an EPA investigation. And why is that? Because the EPA investigation is not a punitive process. It's there to enable the government to recover all of the revenue that should have been paid on those entries. However, this is a case-by-case sort of scenario, and while we have up to 90 days to make our decision on whether to impose interim measures and an additional 5 days after interim measures to provide notice of the investigation that is ongoing, CBP would have within its discretion the ability to notify maybe a small actor that they didn't believe was trying to engage in anything that was inappropriate, maybe at 5 or 10 days out, where they would probably impose interim measures if the goods were obviously within scope, but CBP is not necessarily going to sit, if you will, if there's no reason to sit on those allegations. Now, if they suspect that there are other parties that could be guilty of evasion that are cooperating with the alleged evader, might we be silent for the additional 90 days in order to identify those other parties and proceed against them in some other sort of way? Absolutely, but we're talking about perhaps a sole mom and pop operation. I don't know that the incentive is there to wait the entire 90 days. CBP doesn't have an interest in letting, misconduct continue to accrue, if you will.
But I just would say, to add to that, the CBP is not going to investigate evasion just through EPA. And as a practitioner, when you're concerned about evasion, you're going through the different options that you have to go forward. And certainly, I spent a lot of time when TFTIA was being considered telling everyone that EPA wasn't going to be effective and wasn't going to do anything. That turns out not to be the case. But still, in each one of the places that we're deciding whether or not to bring an allegation, we're making a decision whether or not we go on the criminal side, where we want investigations that's sort of out of EPA, and then work with those parts of the CBP outside of TRLED that would work on those aspects. There, you're not going to get any notice. The investigation will come. It will all be built up before you get told. So there is, the way that EPA works is it has protective measures both for the domestic industries that are filing these allegations and these procedural matters that are in place that importers can look at, and they can use those as protections. But the more that you move it towards pro-importer, the more we're going to move to the other aspects of CBP, where they will have a lot more discretion to take enforcement actions.
With that, I think we'll conclude for the morning. I think you have a 10-minute break, and we'll resume here in 10 minutes. Thanks, everyone. Round 3.
Question is, will there be a round 4?
Yeah.
If at some point this works, I think the answer
Yeah.
is yes.
The TLRAD says that they expect that justice will handle it out of DC.
To be determined. I'm going to lobby to have our office get at least some of them, and I think Gene Davis will be open to that, at least, but it's...
That's good to know. Thank you guys very much.
Thank you.
Hi, Tina, how you doing? All I do is make mistakes. It's been really bad.
Yeah, you know. Open-ended, it's very open-ended. Oh, thank you. No, but I went to law school there.
Me? Oh, I'm sorry.
So, Tina, thank you so much. Take this to lunch in case you got the wrong size or if you want to check for the right size.
That's so cool.
This is extra large.
Extra large.
Extra large, so don't take that one. We've got some time until that thing. This is large, so it's not good. And this is
Swag, I love it.
large. So take a large and then try to take it to the lunch, to our lunch, and then trade it with somebody who got a perhaps a
Otherwise, you
small.
know what? I'll take an extra large and then I'll give it to my husband.
Oh, so this is extra large.
There we go. Perfect.
So
No,
this
that's
is large.
large.
This is extra large.
There we go.
Check it.
Check it. Thank you.
Okay.
Wonderful. Yeah.
So then
You know what?
I think it's an extra large. Is that what you need?
I probably would need an extra. It's a large.
Okay, so what about this? Large. This should be extra large.
Yes, that would work. That would work. Great, thank you.
Get a large, no choice. But if you want a medium, you can take it to the lunch, and maybe somebody has a medium wants to trade it with you.
Okay.
Thank you for coming.
Thank you.
Thank you so much for the
Very kind.
And so there's 3 of you here. Missing. Oh, Bob.
Right.
So I imagine you Tina
Yes. We've had a couple calls. Yeah.
Oh, yeah. She's very good at herding cats.
Yeah, I think we got a plan of action. Well, no, thank you for having us. This is fantastic.
The rare outside, of course, you have the trade update.
Oh, yeah, that's right.
The rare
Absolutely, yeah. Absolutely.
which actually puts me on my toes.
Exactly. It puts everyone on their toes. We got to be up to speed on this thing.
Moments for my students after this.
Uh-huh.
Tell me about teaching them to us.
That's,
I have to make sure
you got to understand the basic concepts first.
50% of my course, the only trade professor that I know that does 50% of my course is the master.
Oh, is it really? Okay.
And then 50 is WTO.
The WTO, yeah. Exactly.
But everybody finds out. Everybody I go to comes, like, only comes twice a year. That I teach so much the lessons. And guess what? 99% of practitioners, all they do, unless they work at Sydney representing foreign governments in Geneva, or what's his name? Guy from Belgium. He's an editor.
Oh, for most, yeah.
But Vermos, unless you represent foreign governments or your own government, in which case you want to request the office, yeah, you're going to be doing domestic international trade.
Well, we get to go over on our stuff. We are involved in the WTO defense on our stuff. Yeah, no, you're 100% right, particularly in private practice in the U.S. Whereas, well, again, unless you're close to like Sydney or London, you're not going to get a lot of opportunity to do WTO.
I did the ECSTR once in Malaysia. You think
Yes.
get case.
Waar heb ik ECOL is practice law longer than I've done. I'm good with stuff like that nowadays. It's no problem.
I won't do it.
Oh, yeah. Oh, yeah. Great. Good for that,
So this case that I spent like 2 months preparing, it's a beautiful get, easy case.
So did you come in from Vancouver? Is that where you've been?
Well, I was there a couple weeks ago, but when we had that phone call. But no, yesterday I flew in from DC.
My pleasure.
Vancouver, do you have a place out there? Go for fun or what?
No,
Most of the time,
the
I
client.
live
I sat in the
New
client
Jersey,
conference
so I'm
room
actually
Oh, so you were working. I thought you were
there,
having fun out
and
there.
then Ohio, Chicago.
Because the practice of
That's
law
where we
is
have our
fun.
office. DC,
Absolutely.
DC,
We're all
and then
blessed.
in Europe.
Did you ever work with Drew Blanford? Or was he more in the investment?
We are not members of ISI because we do not.
You're right,
We
he
only
did. I
plate in the United States.
didn't work
We
with
don't actually.
He's a very good friend. We've known each other since college.
Yep.
Great guy.
Are we ready?
No.
Why do you mean no?
There's not enough people here.
I know, but if I don't start talking, nobody will sit down.
Give it a minute. It's 10:58.
Is it? Oh, that clock
It's
says 11.
11:01.
Oh, I see. You're going off that one.
Yeah, that's 2 minutes back.
You're right, though. It's 10:58.
That's why.
Everybody's looking at their cell phones.
Which I didn't bring up here.
Oh, I'm going to be sitting here.
Put your phone on the
I
table.
guess I better turn mine off.
Yeah.
Hey, Judge Gordon. Great to see you as well. Everything's good. How about yourself? You know,
I do realize I can see the time.
Well, it goes dark.
Oh, it goes dark again.
But that's right, because all you have to do is push that little button. But you don't need that, because you got that.
I know, but you're telling me that's fast.
Perfect. 2008.
No, you're very, very.
Gotta make it a piece. I appreciate you trying.
I was gonna go for a different word. I figure the mics might be on.
Oh, God, the crowd thinned out. Aren't we interesting,
We're
too?
not interesting. It's only still 10:59. I'll wait till 11. Okay, am I allowed now? Am I allowed?
I said it's 10:59.
Still 10:59.
You are authorized as far as I'm concerned.
He's live.
I think so, yeah.
Boom, 11. Okay, we're gonna get started. Okay, good morning, everybody. My name is Tina Petito Kimball. I am Deputy Director, I don't even know what my title is, Deputy Director for U.S. Government Relations for Tata Steel Europe.
She wants to say she's clerk of the Court of International Trade because it comes
That comes
naturally.
easier, but it's not that anymore. So I am excited to be on this panel today with colleagues who really know what they're doing. I will not tell you how long any of us has been involved in trade law. I noticed that both Richard and Nathaniel were eager to tell you that they've been in this business for over 20 years. I will not reveal how long I have been in this business, but let's just say it's long enough. So with me on the panel today, we have Danny Calhoun, who is Assistant Chief Counsel for Trade Enforcement and Compliance at the Department of Commerce. He advises his agency on litigation matters before U.S. courts, NAFTA, and the WTO. The most important thing as far as I'm concerned about Danny is that before he was there, he was with me at Steptoe & Johnson. We rule. Next to Danny is Bo Jackson. He is a partner at Ducci, Mastriani & Schomburg in Kansas City and Washington, D.C. He splits his body in half, I guess. He has extensive government experience in addition to his experience in private practice. He worked at USTR, and he was a member of the staff on the Ways and Means Committee before attending law school. He was also in the Peace Corps. He was stationed in Cape Verde. His practice includes work in the trade remedies area and in Section 337, which is an area we will be covering today. And finally, Neil Ellis. He is a partner at Sidley Austin. His practice focuses on anti-dumping and countervailing duty law. He has represented a variety of industries and governments. Although his practice focuses mostly on representing importers, he has also represented both importers and the domestic industry. With that, I just want to do the standard disclaimer that applies to all of us, which is that these views are all our own. In addition, it's important here, the topic of this panel is we are going to be looking forward. And a lot of these matters that we will be talking about are still active, either at the agencies or in the courts. And so we're going to have to be a little circumspect, some of us, on how we respond and how we address these issues, because many people on this panel are actually involved in these very interesting topics, right? That's how come we earn a living. So, we might not be as concrete as you would otherwise want us to be on these issues.
So hopefully our opposing counsel hasn't sent spies today or anything.
Well, Heather's up there.
Opposing counsel.
That's true, yeah, that's true.
Nice. So these issues, when you're talking about trade issues and what's happening in trade, for me it's exciting, and that's why I love practicing in this area of the law, because these are issues that are hotly contested, they have political undertones, and it changes, the landscape changes, depending on what administration is in place and how they are choosing to use these laws. Right now, I'm sure we all know, the current administration is very aggressive in their use of the trade laws. I work in the steel industry. The steel industry, the 100-pound gorilla in the room is China, right? But it's not just for steel industry. It's for many industries that the trade imbalances and things, it's very much China focused. Unfortunately, what's happening is the good importers, such as Tata Steel Europe, are getting swept into these nets of, these remedies are being applied, and they're being applied across the board. And so it's an interesting time because you have this, quote, bad actor, this entity, the China machine, that everyone knows is where the target lies, and so many other companies are getting swept in. So in this panel now, we're going to discuss that trade landscape and how then the use of the trade laws is being overlaid on that landscape to hopefully, provide a more balanced trade scenario. So Danny is going to talk about what's going on, sort of what the administration is doing right now with that backdrop.
All right, thank you so much, Tina, and it is indeed a pleasure to be here today. I have to admit, I perhaps somewhat naively held out some hope that I would be here in Cleveland during an Indians Nationals World Series. But I guess that wasn't meant to be. Yeah, I know. Well, it hurts for me too, because yeah, that is true. Well, I had actually booked my flight home this afternoon so that I would be able to be at Nationals Park for a Game 3 tonight, were there a Game 3. So be that as it may, we'll go to the topics. First, I'd like to thank Professor Colares and the conference organizers for having me here today and having us here as a panel, and to thank Tina, my fellow panelist. And I would just reiterate the sort of standard disclaimers that Tina just mentioned, specifically the one about sort of active matters. There are probably some things I probably am not in a position to talk about overly specifically, but I'll try to make whatever general comments I can. That being said, I would agree that the theme of this panel, alternative trade remedies, policy, and legal developments, old meets new, really cannot be more timely. Obviously, as Tina just said, the current administration has made trade enforcement a top priority, and I think that's being seen in several manifestations. First, there's sort of the traditional trade remedy tool of the anti-dumping and countervailing duty laws, which is probably, I would say, are probably the primary tool historically that domestic industries have used to get relief. Just for those, I recognize that maybe not everyone here is a practitioner or maybe hasn't had the benefit of taking Professor Claris's class yet. So I would probably just take a quick step back just to make sure everyone knows what we're talking about when we're talking about dumping and countervailing subsidies. And again, these are more general descriptions, not necessarily the legal definition, but the legal definitions are obviously in the statute for those who want to refer to them. But dumping generally refers to when imported goods are sold in the United States at less than fair value. And fair value is usually what the price for the same good, for what the same good is sold for in the home market, or if that price is not available, an appropriate proxy. And countervailing subsidies typically refer to financial contributions from a government that are specific, i.e. they're not broadly available and confer a benefit. And these tools really have their origin going back to the late 19th and early 20th century. So they've been around a long time, and I think that's probably why they sort of are considered the more traditional tools that are at their disposal. And, you know, they continue to be used in record numbers, despite some sort of these other alternatives we're going to talk about today. I hate to break it to you, Judge Gordon, but since January 20th of this year through Wednesday of this week, the Department of Commerce has initiated 77 new investigations, which is a 61% increase over the same time period of last year. So the workload is not diminishing, it's only increasing. And in response to sort of the question we had earlier about sort of why is that the case, I think Judge Gordon's response is correct, is that it is countercyclical, and the point that Tina just made is correct as well, that if you look at many of the investigations, or a good number of the investigations that we've initiated over recent years, in the last couple of years, a lot of them relate to steel products, but aluminum products, or products that use steel or aluminum as inputs. And of course, these are products that are going through a stage of sort of excess capacity that's, you know, caused in part by what's going on in China. And while, you know, the countries are sort of having these global steel forums over in Paris on a regular basis to try to resolve this problem, in the meantime, domestic industries have to use the tools that are available to them, and that's primarily the dumping and countervailing duty laws. But that being said, you know, and then as we'll get into later in the presentation, there are a good number of other tools that are now being used in increased frequency. So some of the ones we're talking about are Section 201 investigations, which are safeguards, which are typically before the ITC, Section 232 investigations dealing with national security concerns, particularly in the steel and aluminum sectors, that is currently before the Commerce Department, although a different unit than my client. Section 301 investigations about actionable trade practices involving technology transfers, and of course the 337 investigations that Bo is going to talk about. So I guess one of the questions is that do these sort of increased reliance on new tools speak to the ineffectiveness of traditional trade enforcement tools like the AD/CVD laws? And I think the answer to that is maybe perhaps. I mean, we obviously still are getting a record number of petitions coming in the door and are initiating a record number of cases. But it's important to note that in the case of the 232 investigation, and I know that Neil's going to talk about it in greater detail, I would note that a lot of the orders that we've imposed, we have multiple orders on steel products for multiple countries, but of course that seems to have not addressed some of the concerns, particularly presented in the national security context, in terms of the duties that have been imposed on those products. Similarly, in terms of the Section 201 investigations, particularly the one on washing machines. In his remarks this morning, Professor Colares talked about sort of the dumping orders and the CVD orders that have been imposed on washing machines from Korea and Mexico. But I think part of the reason, and I think this is widely known within the trade bar, is that part of the reason that the domestic industry had pursued that safeguards case on washing machines is sort of in recognition that every time they got an order from the Commerce Department, whether it was from on products from Korea or products from Mexico, and eventually products from imports from China, that the primary producers, which are LG and Samsung, would just move their production facilities somewhere where there's not a AD or CVD order in place. And, the anti-dumping and CVD laws are a bit clunky in that, they're expensive cases to bring. They take some time to resolve themselves. Of course, they're subject to judicial review and WTO dispute settlement. So, these tools are not necessarily the most sort of nimble at times. And so, I think that's a large reason why domestic industries and the administration on its own are looking to sort of other options. But to that end, I'm going to focus the next few minutes just talking about some of the increased emphasis or potential reinvigoration of tools that we have available at the Commerce Department in our anti-dumping and CVD proceedings, and then I'll turn it over to the other panelists to talk about some of these other tools as well. So the first thing I'm going to talk about is self-initiation. This is something that some of you who are following the trade press have probably seen a lot about in recent months. Traditionally, Commerce conducts its AD and CVD investigations upon being petitioned by a domestic industry. And usually these petitions have certain sort of threshold requirements they have to satisfy, including making the necessary allegations of dumping or subsidies, but also they have to sort of hit certain industry support standards so that there can be some sort of assurance that the petitions are being brought up on behalf of the domestic industry. However, the statute, as well as the relevant WTO agreements, do contemplate that Commerce can self-initiate anti-dumping and CVD investigations. However, the Commerce Department has only done that on a handful of occasions. I think the total number is 3, and the last one was in the early 1990s. But Secretary of Commerce Ross and others in the administration have publicly stated their desire that Commerce self-initiate more investigations. And that is something that I think we're in the process of looking into and figuring out what might be the best way to do that should we decide to do it. I think the advantages of the desire for increased self-initiations do reflect that certain industries may not be in the best position to actually petition for the relief. As I noted earlier, there are certain petition requirements, particularly with respect to industry support, that sometimes can present problems for a petitioning industry that, in the context of self-initiation, would not necessarily be an impediment. I would also note, just as a practical matter, that it is expensive to bring a trade case. And industries and companies suffering injury who are distressed in some way may not be able to afford that cost. And so self-initiation might alleviate some of that burden. There's also some other considerations. For instance, a U.S. company that has operations or investments in a foreign country and is thinking about bringing a trade case, AD/CVD action against a product from that country, an imported product from that country, might be worried about retaliation, in terms of having sort of business deals quashed or something like that. So in that respect, self-initiation might bring certain advantages and might alleviate some of those burdens. However, I think it's important to emphasize that self-initiation doesn't alleviate all of those burdens. On the commerce side, of course, I think we talked about this morning in the opening remarks from Professor Colares, of course, the AD/CVD is a bifurcated process where Commerce examines whether or not there's subsidies or dumping going on, but the ITC looks into the question about whether domestic industry is injured. Now, before Commerce, once we initiate, typically the burden to provide information falls mostly on the respondent, the foreign companies and governments. But at the ITC, it falls also a large degree on the domestic industry, who has to provide enough information for the ITC to conduct its injury analysis. So it's important that they do be able to participate sufficiently in the ITC proceedings so that the ITC can make the necessary findings if they are going to provide that relief. The next thing I'll talk about briefly will be suspension agreements. Again, under the statute, the Commerce Department may quote-unquote settle an AD or CVD investigation by entering into an agreement with foreign exporters or or in an AD investigation of a non-market economy country such as China, or a CVD investigation with the foreign government. These agreements suspend the investigation in return for an undertaking by the foreign exporter or government to revise its prices or export volumes. These agreements are generally very rare and do generally require the consent of the U.S. industry before entering into. I think what's of note here is that the Commerce Department in the last year, particularly under the current administration, has certainly signaled an openness to consider these suspension agreements with greater frequency. Earlier this year, the department renegotiated a pre-existing agreement, a suspension agreement involving sugar imports from Mexico. And in a couple of very high-profile ongoing investigations, softwood lumber from Canada, and just this week in the investigation of biodiesel imports from Argentina and Indonesia, Secretary Ross signaled his openness to actually enter into these suspension agreements negotiations and to try to find a negotiated solution. Now, the advantage of these suspension agreements is that they are a negotiated outcome and reflect voluntary commitments by foreign exporters and governments, and are subject to enforcement mechanisms. And they certainly have the advantage of alleviating trade frictions and sort of bilateral relationships. However, I would note that there are numerous substantive and procedural requirements before entering into these agreements, which is partly why why they've traditionally been so rare. The next thing I'll talk about briefly, and I think this will be the last one, the tool is anti-circumvention. As we talked about on the last panel, of course, Commerce has a possible role in these in the EPA investigations, but the Commerce Department also does have the ability to investigate what's called circumvention, which is a concept sort of related to evasion. And I think we typically identify 4 types of circumvention: where the merchandise is completed or assembled in the United States, the merchandise is completed or assembled in a third country, minor alterations that remove the merchandise from coverage of an AD/CVD order, and merchandise that is very similar to merchandise covered by an order, but which has been developed subsequent to the initiation of an investigation. Now, this tool has been on the books for some time, and we have used it numerous times in the past at the Commerce Department. Probably a famous example is what we call the pinch of boron cases, where you have a steel order that has a content requirement, a maximum content requirement for boron, and the foreign producer adds just enough to get it over that threshold and then claims it's out of the order. In that sort of situation, we would look at that as a minor alteration or potentially a subsequent developed merchandise, and have found in such cases the merchandise to be subject to a pre-existing order. But what we have seen more recently is that anti-circumvention has sort of been a tool that's also been used at sort of these evasion issues. Currently, the department is investigating with respect to orders of corrosion-resistant steel and cold-rolled steel from China, whether products that are produced and exported from Vietnam that were made with inputs from China should be subject to those pre-existing orders. I think I'll wrap up there. I'll make one general observation. Another tool that's also been used is sort of change circumstances reviews, which has been a tool more to actually exclude companies from orders, but maybe more recently, of course, in one example this year, has been used to actually been used more for an enforcement purpose. But I think I'll leave it at that, and we'll turn it back over to Tina.
Professor, I just want to congratulate you for your forethought by not putting Neil next to having them in the middle. Actually, was because I know you are ready to jump at the 201 characterization. But before we go there, do either of you have any comments on sort of what Danny characterized as the reinvigoration of those anti-dumping countervailing duty tools? No? Bo, you do.
Yeah, so I would just make one high-level observation. Obviously, Danny covered the AD/CVD process and what's going on from the commerce standpoint. But we all have to remember, of course, that there's the ITC side of these cases as well. And I just think it's noteworthy, and Neil can talk about it more if he's able to, because he worked on the case. But there was the first negative preliminary injury vote at the ITC in a long time. I think since 2009. He paid me to set him up like this. In the titanium sponge case, I think it was Japan and Kazakhstan. And so, yes, we are in a time of increased trade enforcement. It's coming directly from the administration. The domestic industries are hungry to bring cases. The petitioner's bar is hungry to bring cases, and all that's well and good. But I think we all have to stop and remember that there are evidentiary requirements that have to be met, including at the ITC, and it's not always a slam dunk that it's going to be injury and therefore duties imposed. So I thought that was noteworthy.
Okay, so now, Neil, we have, the 201 safeguard investigations, and we haven't had one in, 15 years?
Right.
And all of a sudden we have two.
Right.
What's going on?
So just to give a little more background, if I may, on what 201, some of the important aspects of Section 201, so-called safeguard cases. It's important to keep in mind they're unusual because they authorize restraints against imports of fairly traded goods. In other words, there's no sense of unfairness, either no dumping, no subsidy, for example, and there's no necessarily a national security implication either. So the Department of Commerce is not involved. It's exclusively in front of the ITC, and then it goes to the president. What rather is focused on is the impact that fairly traded goods are having on an industry in the United States. And I should note also, by the way, I am involved in small ways in both of the 201 cases currently pending, so I can't talk a lot about the details of the cases. But the point is to provide a U.S. industry that is being overwhelmed by rapidly increasing imports of a given product into the United States, give it breathing space is the term that's used, to prevent imports or reduce imports for a while, to permit the U.S. industry to restructure and to become globally competitive again. So because you're bringing restraints against fairly traded goods, there is both a higher injury standard and a higher causation standard than is usual in the anti-dumping and the countervailing duty cases. That is, instead of just a cause of material injury, as you may know from anti-dumping and countervail, it's a substantial cause of serious injury. Now, to some extent, you're just playing with adjectives, which I think matters, but nevertheless, there is this clear understanding that both the level of injury and the causal connection to the imports are supposed to be heightened. Because you're bringing cases against fairly traded goods, there's an uneasy relationship, if you will, between safeguard cases and the fundamentals of international trade, which since the GATT and then the WTO is based on the idea that fairly traded goods, fair trade in goods is a good thing. Nevertheless, the safeguards are not only permitted by the WTO, but in fact subject to an agreement, so the WTO agreement on safeguards, so there's an understanding that this is a legitimate escape valve, escape clause is what the term is sometimes used, that has been endorsed by the multilateral trading community. Just a couple of items, a couple more items. On substance, the ITC is, and then the president are permitted to impose both import restraints, quotas, or tariffs on these import duties, on these imported goods, or a combination. It is what's called a TRQ, trade-related quota, which is where you have goods are permitted to come in at without quota, tariff-related quota, that's right. Without tariffs up to a certain level, and then above that level, they then would be subject to tariffs. Now, there's an unusual aspect to this case also, in such cases, in that instead of having the Department of Commerce and ITC, you have three inquiries. Two at the ITC, one before the President of the United States, which obviously is quite unusual. So first the ITC looks at whether or not the level of there is injury of the level that's required. And then it looks at, if so, then it finds what remedy would be appropriate, and it recommends the remedy to the President. Then the case goes to the President, who has 60 days to decide what to do. And his segment of the case is usually handled by the Office of the U.S. Trade Representative with an interagency assistance. The President can adopt the recommended course of action by the ITC, or he or she can do nothing and then explain to Congress why, or the president can take some modification, some remedy, but a modified version of what the ITC has recommended. So you end up having a large, which we're involved in now, a large structure of proceedings in front of the ITC with injury and then remedy, but then the remedy phase kind of falls very intensely into the final 60 days where the president actually makes the final determination. And because this hasn't been done since 2002, as Tina pointed out, there's not a lot of case law, there's not a lot of predictability on what the president phase will look like. There was a flurry of cases in the late 1990s and early O's leading up to the massive case against steel products. But every time that the U.S. government issued restraints under the safeguard cases, one of the unhappy trading partners went to the WTO, challenged the United States, and every time the WTO found that the United States had in fact violated its obligations under the safeguard agreement I mentioned. So as a result, people got kind of tired of it. They said, why bother? You're going to get remedies, and then 2 years later or whatever, they're going to get stricken down by the WTO, and the president would have to withdraw them. So people stopped doing that until this year when you've got the two cases that Tina mentioned. One against solar panels and solar cells, and another one against washing machines. The last point I want to make on this goes to something that Danny said, which is in washing machines in particular, the petitioning industry, Whirlpool primarily, expressly said that the reason that they were bringing this case was because of so-called country hopping. That is, the Korean producers it was an anti-dumping case against washing machines from Korea, so they moved to China. There's a case against China, and now there's an anti-dumping order on China, and now they've moved to Malaysia and Thailand and Mexico to some extent. But the problem with that conceptually, that sounds reasonable, right? You want to stop this country hopping, anti-dumping cases are expensive and inefficient, you want to stop that. The problem is, remember what I said earlier, is that conceptually you're dealing with something very different. You're not dealing with country hopping of unfairly traded goods. You're dealing with a global problem. Safeguard cases are brought globally, not country by country, against fairly traded goods. And the point is to give breathing space to the U.S. industry because they can't even deal with fairly traded goods, and they need a couple years to deal with that, to propose methods of reconstructing themselves. So by turning that into a case where you bring against a bunch of countries that are ostensibly engaged in unfair trade, you're kind of muddying the water as to what a safeguard should be doing. And we see where in these cases you are bringing in the flavor, the atmosphere of unfair trade into a case that's really supposed to focus just on fairly traded goods, and you lose those adjectives I talked about because, again, you're saying, well, look, these unfairly traded goods were found in Korea or China, and now they're in Thailand, and you lose the difference between material injury and serious injury, or a cause versus substantial cause. So one, I would submit, without getting into more details, you have to be careful conceptually to make sure that the case is doing what it is, what the law and the agreement were meant to do. Thank you.
Okay, so we just had a very good lesson on 201, and I don't know if, Bo, you have anything to add to that conversation, but I know that in addition to that, if you do, then 201, a tool that is very little used and now being revived, then we turn to something else the ITC deals with exclusively, no commerce participation, and that is the 337 laws, which have been used, continue to be used, are used all the time, and yet we're talking about them being used in a new way. What are we talking about?
Yeah, that's a great lead-in, and the only thing I'll excuse me, comment on from what Neil said is it's funny for us trade lawyers how much overlap there is. I mean, I'm sitting here thinking about, Danny mentioned changed circumstances reviews, and now Neil's talking about the solar safeguards case, and I've got a client, and they wouldn't mind me saying this, who's currently trying to get out of the existing AD/CVDs on solar panels, either through a scope proceeding or through a changed circumstances review, with the blessing of the petitioner, only then maybe to turn around and get hit with the new safeguard tariffs from the ITC that are going to be coming. So it's a crazy time where we're all sort of working on various fronts, same types of products, but across various cases before different agencies and courts. So it's fun. So Section 337.
Fun for the lawyers.
It's fun for the lawyers, yeah.
That's right.
Maybe not for the companies.
Definitely not for the company.
Yeah, that's right. So just by a quick show of hands, who in this room has heard of Section 337? So a little over half, I'd say. I find that to be the case often when I'm speaking at trade panels, and I love the opportunity like this to sort of bring the 337 world back into the trade world, because it's become a little bit more known as an intellectual property litigation world. But as a trade lawyer who practices in the area of Section 337 as well as traditional trade remedy stuff, I like to bring these two groups together. So that's what I'm going to try to do, is put it into the context of everything else we're discussing. So Section 337 is a border enforcement remedy that says it is unlawful to import unfairly traded goods, and the remedy that is imposed by the US ITC if they find a violation of Section 337 is not extra tariffs, it's a complete ban on the importation of those products. So it's an extremely powerful remedy that a lot of people forget about, a lot of US companies don't think about using, because if you win the case, if you show that these are unfairly traded imports, you block those competing products from the US market completely. So that's what we're talking about here. What do you have to do to show that? Basically 3 or 4 core elements: an importation of a product in the US market, or the sale for importation or sale in the US after importation, which means you can name the foreign respondent, the foreign producer, as a respondent. You can name the U.S. importer as a respondent, and you could even name retailers, U.S. companies reselling the goods, as a respondent. So you have an importation. You have to have an unfair act, which in about 90% of the cases is infringement, excuse me, of statutory intellectual property, so a patent, trademark, or a copyright. But there's a lot of cases now that we're seeing that do not involve any intellectual property at all, so that's good to see. And domestic industry. But this is important, especially for the, what I would call traditional trade remedies folks in the room. It's not a U.S. producing industry. You just have to be doing something in the U.S. with respect to the types of products you're trying to protect, to avail yourself of Section 337. So you don't have to be a manufacturer. Statute says if you're making investments in the U.S. economy through R&D, through engineering, through licensing intellectual property, and through traditional things like plant and equipment and production, then you have a U.S. industry for purposes of 337. So it's different than the, quote, domestic industry for AD/CVD cases. And then finally, in cases that don't involve statutory IP, the complainant has to show injury. So that is more like an AD/CVD case. The complainant would have to show that it's been injured or is threatened with substantial injury from the unfairly traded imports. So that's the background on what 337 is. What can you get from it? I already talked about the ban on your competitors' products into the U.S. market. So you get an exclusion order and a cease and desist order, which says the inventory of those products that are in U.S. inventory cannot be sold. So they've already been imported. Yeah, but what if they're already here? Well, you get a cease and desist order that also prevents the domestic sale of those products. But there are public interest factors, and this is another cool twist to 337 that makes it more of a traditional trade statute. So a complainant shows that its IP was infringed, or shows that there was an unfair act in the importation of a product, shows it as U.S. industry, and therefore it's entitled to this border enforcement remedy. Yes, although the ITC also has to consider certain statutory public interest factors, namely whether the remedy would adversely impact U.S. consumers, public health and welfare, competitive conditions in the U.S. economy, et cetera. So in most cases, these public interest factors are not a problem. It's very rare for the ITC to completely not issue a remedy because of them, but the ITC is definitely paying increased attention to these public interest factors, in part because of some scrutiny from Congress. Congress in the last couple of years has been holding some hearings and looking into whether the ITC is issuing these broad remedies without thinking through the potential public interest impacts. And I just wanted to note this because it came up on our call the other day, preparing for this. Again, talking about you don't have to be a U.S. producer to bring a 337 case. In the last few years, 337 cases have been filed by a company from the British Virgin Islands, which I'll take a little credit for that one. Lego from Denmark, Daimler, Germany-based company, Fujifilm and Canon and Seiko Epson of Japan, Nautilus of Korea, Aker BioMarine of Norway, and a whole host of others. So in contrast to the AD/CVD laws, we do see foreign headquartered companies using Section 337, as long as they're making the requisite investments in the U.S. economy. But I guess that's not so unusual because isn't in the solar case the U.S. producer, but they're a foreign headquartered company, right? Mm-hmm. So maybe our worlds aren't quite so different. So with that, I'd like to just briefly touch upon a few noteworthy 337 cases that are going on or have happened in the last couple years. And since steel keeps coming up today, I'll start with that one. Many of you have probably heard of the 337 case filed by U.S. Steel. So they already had a bunch of AD/CVDs in place, right? They'd been fighting hard on this. But they thought there was some evasion, some circumvention going on. Maybe they weren't happy with the tariffs, didn't think they were sufficient. So I think, somewhat intelligently from a tactical standpoint, they said, let's file a 337 case against the exact same types of products. And specifically, I think it ended up being oil country tubular goods, OCTG products. And they had three specific claims that they said were a 337 violation. Trade secret misappropriation, saying that their foreign competitors, mainly Chinese companies, had stolen their trade secrets and used those to make competitive products. False designation of origin, and this is what dovetails with the AD/CVD orders that were in place, saying they were transshipping the products through third countries to avoid the AD/CVDs. And then finally, some antitrust violations, basically saying that some foreign steel producers were conspiring to fix prices and control output. So some really cool allegations that, again, most people hear 337, they think patent litigation, but this case could not be further from that. Unfortunately for U.S. Steel, it hasn't gone super well. By the way, disclaimer, I'm not involved in the case, but my firm does represent some of the companies as well as a few of the other cases we're talking about. So speaking here only on myself, my personal behalf today. So the antitrust allegation ended up getting ruled upon by the administrative law judge, motion for summary determination, which is the ITC's term for MSA. And they said, yeah, that U.S. Steel had not properly pleaded antitrust injury. That decision is currently pending review by the full commission. So right now, one of the three already is maybe done. Another allegation was pulled by U.S. Steel, the trade secret claim. I'm not sure why, but I guess they didn't have the evidence to meet that showing. And then finally, just a couple weeks ago, the administrative law judge granted a motion for summary determination on the falsely designated claim, saying that there was not sufficient evidence for them to meet their burden to show that the imports of these steel products were being transshipped, et cetera. And U.S. Steel, I don't think, petitioned for commission review of that one. So as it stands, as we sit here today, the case is all but dead, it seems like, unless the commission were to revitalize it with the antitrust aspect of it. So a really cool 337 case that overlaps with a lot of the trade remedy stuff that we're talking about, especially because it was a 337 case brought on products that already had AD/CVD orders in place. Just two other quick ones I'll note, kind of cool 337 cases. There was a bed sheets, U.S. bed sheets company that brought a case saying that bed sheets imported from India were falsely advertising their thread count. They were 300 thread count and they were advertising at 800, which of course makes sheets softer. And most of the respondents in that case didn't show up. So the ITC issued default judgments against them and issued a general exclusion order, basically barring the importation of any bed sheets from India unless the importer can prove that somehow they don't falsely advertise their thread count. So that was a very successful case by that U.S. company to ban the importation of competing bed sheets from India. Again, no connection to intellectual property. That was a false advertising case under the Lanham Act that was remedied by the ITC. And then finally, the last one I'll mention is a case I'm currently working on. It involves Roe v. against Comcast, Technicolor, and Eris concerning set-top boxes. And an interesting issue that's currently on review by the Commission is whether the importation of a cable box, that we all have, that does not infringe at the time of importation. This is a patent case, if you can't tell, but may be used to induce infringement by Comcast customers down the road when they use their remote access app to record certain channels, et cetera. Whether the ITC can properly issue an exclusion order banning the importation of that box, the cable box, even though the box itself is just a staple article of commerce. It is not infringing at the time of importation. So how is the ITC going to rule in that case? It's going to be interesting to see. I expect this will have to go to the Federal Circuit. So there's a case from the patent context that we're seeing some interesting trade implications on as well. So that's my, my quick spiel on how 337 fits into all this other stuff.
So, and that's an interesting, it ties with this morning's panel or what Judge Gordon said about the Ford case and how you change things when it comes into the United States. I mean, it's so incestuous. Okay, and so then the last topic that we want to touch on before we open it up for questions has to do with something that I think is rocking the world of all of the trade geeks around, right? And that is that normally trade remedies or, trying to somehow inject the government into the trade sphere is done by a U.S. company making an allegation against another company, right? So Nathaniel's client goes to the government agencies and says, Tina's company is doing bad behavior, right? Which of course would never happen. But that's how the normal path works. Except lately, we have seen the administration itself really jumping in, even more than just the self-initiation that Danny was talking about. We are seeing this administration engage in the mechanics of trade. Shocking, shocking, this administration is engaging in unusual behavior. But we are going to talk about that now. We're going to have Neil talk about the 232 and the 301 investigations. And that's truly not new, but definitely unusual.
Right. So 232. So this is Section 232 of the Trade Expansion Act of 1962. I bet you, if you were honest, nobody in this room ever heard of that. And when these cases were launched, they caused hundreds of members of the trade bar to scurry off their treatises and look at the last chapter, which is kind of random miscellaneous trade legislation. So it's been invoked 26 times since it was enacted in 1962. Of those, only 5 times were remedies imposed, the last time in 1988. Since the U.S. succeeded to the WTO, this law has been invoked only twice, and both times the president declined to take action. So what's it about? This law authorizes the Department of Commerce to determine whether imports of a product are, quote, in such quantities or under such circumstances, which is vague, as to, quote, threaten to impair the national security. And if so, then the president may take action to, quote, adjust the imports of the product at issue and its derivatives, meaning downstream merchandise, or may take such other actions as the president deems necessary. So this is the Wild West, basically. A couple interesting points, since we're short on time. One is obviously the invocation of national security. We're well away from commercial issues. And recall, 62, this was the height of the Cold War. The Berlin Wall had just been built. And Congress felt it was appropriate to give the president authority to deal with imports on, that have national security implications, Cold War implications at the time. Moreover, the concept of security is broadly defined expressly in the statute. It's not just national defense. So we're not talking about imports that might somehow, a flood of imports that might undermine our capacity to build missiles or aircraft carriers, which is the core concept. But also, it means also economic welfare. And again, the statute expressly talks about that. And that could cause, quote, that could lead to, quote, substantial unemployment, loss of investment or specialized skills and productive capacity. So if you take a look like the last two cases I mentioned in the 80s, when these were imposed, they were targeted against imports of oil from Libya and Iran, seen as being national security, having national security implications. Nothing to do with them somehow undermining the U.S. oil industry. Another interesting point about this statute is that in addition to the very minimal description of the substance and the remedies, there's also minimal procedures authorized in the statute. Even Section 201, which I described, and 301, which I'll get to, have very elaborate procedures established and that the agency and the president are required to follow. Here, there's basically nothing. The Department of Commerce has implemented regulations, but they are also quite minimal. It simply tells them they can do whatever they want. The goal is within 270 days, the Department of Commerce has to recommend proceedings to or remedies to the president, and the president then has 90 days to act, and that's about it. One other interesting aspect of this statute is whether or not there is the concept of judicial review even exists. And I suppose it does because of the residual jurisdiction under so-called Section 1581I we heard about earlier today. That is, it clearly is a statute or a remedy that would have an impact on imports. But whether or not, it's never been tested. There's no case law. Judicial case law, as far as I'm aware of, under the statute, and whether or not a court, the Court of International Trade or the Court of Appeals or the Supreme Court for that matter, would second guess a decision of the United States President on national security grounds is doubtful. There also theoretically is a possibility of WTO challenge, but because again, the WTO generally says that fairly traded goods are to be permitted. But there is an exception, Article 21 of the GATT, I don't know if you studied this, which does permit governments to impose restrictions necessary for essential security interests. So the question is, would a foreign government bring a challenge against the United States imposing remedies or restrictions under this act, claiming that the United States in fact acted in bad faith and that they were not imposed for the purposes of protecting the U.S. quote, essential security interests? I would be doubtful as to whether a government would do that, or that would be really like the third rail, if you will, of the dispute resolution at the WTO, because it would be very risky for a panel or the appellate body to declare that the United States or any other government for that matter would be acting, was not in fact acting in its essential, to second guess a determination on whether remedies were in the essential national interest. But on the other hand, if the United States were to do this, then the question is whether or not there would not be reciprocal behavior by China or Europe or anybody else saying that, well, we're going to impose restrictions on imports of U.S. soybeans because they're contrary to our essential security interests. So you can get into a real problem with the WTO, I think, if this is pushed to its logical extreme. What's interesting is that the President and Secretary Ross said that they were going to act quickly. I said they're 270 days. When the cases on aluminum and steel were launched in April, they said they were going to decide that the Commerce Department would issue its recommendations by the end of June, and that hasn't happened. Because what you discover is that the United States has a large and complex and interesting economy, and the interests are diverse. So they started having a lot of blowback or pushback or whatever on the idea of imposing significant import restraints on steel and aluminum products especially when the Department of Defense, which again is the core constituent here, said that has generally said that imports of steel are not significant or troubling for a national defense focus. So, so now at the moment we are just drifting along. Secretary Ross has now said that, well, he might wrap in any remedies under 232 into the tax reform, which has become the latest focus of government efforts in Washington, and thereby give relief to the steel and aluminum industries through updating tax rules, rather than and kind of let the 232 investigation die. So it'll be very interesting to see what happens here. On 301, am I supposed to go on and talk about that? On 301, I'm getting tired of hearing myself speak. Are you guys getting tired of this? Just quickly again, this is kind of a grab bag. It permits the United States to impose restrictions on imports when the rights of U.S. under a trade agreement are being denied, or an act, policy, or practice of a foreign country violates a trade agreement, or it denies benefits to the United States under a trade agreement, or is unjustifiable and burdens or restricts U.S. commerce. You see, we're getting pretty broad here. Or it is unreasonable and discriminates U.S. commerce. Now, 301 was challenged almost immediately to WTO, and it was found not to violate the WTO by the skin of its teeth, so to speak, because the statutory language was found on its face to breach the United States obligations under the GATT itself, none of these sub-agreements we're talking about. But the panel, the WTO panel, did something unusual. They took a look at the legislative history, the Statement of Administrative Action, it's called, when it reenacted Section 301 in 1994. And there they said, and the United States made commitments before the panel that it did not have to be interpreted in a way that would violate U.S. obligations. And therefore, you couldn't, as a facial matter, say that the statute was always wrong, always in violation, and rather you'd have to look at individual decisions to see whether or not the United States, in a particular case, was violating its WTO obligations. Since that time, it's not been used in the United States. I think one reason could be that if you used it in individual cases to bring restraints on trade from specific countries, you would in fact then be violating the most favored nation aspect of the WTO agreements. So there's been some recognition, I think, that it probably is not the best avenue, because it would end up being stricken down by the WTO at the end of the day anyway. But then this year, just a couple months ago, a case was launched against China and its various intellectual property practices, so it kind of interfaces with other remedies that are being considered and used on IP. And these are allegations in particular that, the Chinese government uses a variety of tools to pressure U.S. companies doing business in China to transfer technology and IP to Chinese companies, pressuring U.S. companies doing business in China not to get the full market value of their licensing fees and for the use of their technology. And also the Chinese government facilitates the acquisition of, allegedly, of high-tech U.S. companies in the United States by Chinese investors, which then would permit a large-scale technology transfer back to China. So this case is pending. It's in its early stages. The USTR held a public hearing a few weeks ago, and where it was the Chinese interests who showed up and had the bravery to testify were faced with a barrage of hostility and hostile questions. So the USTR now will be deciding what remedies to impose and how to deal with this. I suspect that these sorts of problems will have to require some sort of negotiated agreement between the United States, and the president is going to China, I think, later this year, in order to resolve problems that are this kind of systemic and structural. But it's very interesting. I'll stop there.
So we have 5 minutes. Anybody have any questions? Yeah.
I have a kind of bizarre question. Listening to the Whirlpool stuff, I was wondering whether any of the agencies or tribunals' dedication to address, I guess, consider the valuation of Internet of Things data in dumping cases. That is, where these products are generating, data that has a tangible, quantifiable market value to the importer post-importation and post-liquidation. Does that affect the calculus of whether or not the goods are being sold below cost?
I'll maybe take that one, and Neil can weigh in. Generally not. Generally, a dumping calculation is typically a straight price comparison. So we would look at the price in the home market, compare it to the price, the export price of the United States. And I think some of the sort of criteria or data points that you're talking about really would not be sort of independently considered unless being reflected in the price.
I want to make sure I understand. So you're saying, does data considered that looks at what?
So these washing machines, for example, have operating systems in them. They talk to the internet. They tell Samsung, how often you're washing your clothes, what brand of detergent you're using, all of this data that has marketing value. So part of their, hypothetically, part of their position might be, yes, we are selling this at or below manufacturing cost, but we have this recurring stream of revenue associated with this marketing data after the sale that, at least in domestic trade law, I think would be relevant to, whether or not it was a loss leader product and whether it was an appropriate loss leader product. But it's distinct in a way that the ongoing revenue is not a service contract or something, as you might have in some instances. It's not being paid by the consumer.
Yeah, well, as Danny said, the short answer is no. They look at the value of the product, the hardware, as it were, at the time of sale in determining whether or not a dumping margin exists. And Whirlpool or whoever would argue that, they have parallel systems and the value, the injury to them is being caused by the product that they are not, the opportunity to make a sale that they've had to forego because the price of the imported product was, as a product, was too low. One thing I'd point out, by the way, I have worked in the washer's case, and one thing I'd say, modern washing machines, for an old guy like me, are really cool.
Yeah, they are.
They do stuff that, they're not just a white box in your basement anymore. And LG and Samsung have argued on the injury side of the case that they are the innovators that have fundamentally shaken and reshaped the U.S. appliance industry. But nevertheless, the dumping when you get to the dumping side as opposed to injury, you look at the product that's sold.
I would add one thing on that is that in the dumping calculation, I don't think what you're talking about would be really relevant, but it could be relevant in the subsidies context to the extent that those type of technologies were the benefit of like R&D subsidies. In that case, as long as those subsidies were determined to be injurious by the ITC, then that's possible that something like that could fit in. But actually, the added value I think that you're talking about really would not factor into at least what the Commerce Department does.
So we are running out of time, and there's one thing that I did learn at Clerk of Court is that if a judge has a question, you let the judge ask the question. And he has a question, so.
You spoke about suspension agreements.
I want people in these questions. We can go a little bit.
Can you comment on
I want to encourage.
characterizes the finality of suspension agreements? My sense is you may have left the audience with the impression that if there's suspension agreement, that's the end of it, and you and I know that they're subject to judicial.
Oh, absolutely, and I apologize if I left that impression. So suspension agreements are very much subject to judicial review and WTO dispute settlement. There are provisions in the WTO agreements with that. Suspension agreements are basically procedures that are defined in our statute and are subject to judicial review. So in that respect, even though they're negotiated outcomes, There could very well be a party that maybe didn't get exactly what it wanted, and could very well, bring suit at the CIT or potentially even under a NAFTA panel or at the WTO. Additionally, is that these agreements could be subject to renegotiation over time, which I mentioned the one involving sugar from Mexico, where the terms did change to some degree this year after a renegotiation. And again, if you renegotiate, that itself is subject to judicial review.
One thing I want to mention, by the way, if I may, on the washers case, at the introduction, Professor Clavares mentioned two cases which our law firm's involved by sheer coincidence, Ford and washers. And what's interesting in particular about washers, although this is a topic for an entirely different seminar, is the parallel relation between judicial review and WTO challenges. Because, as the professor noted, the CIT affirmed the finding of both dumping and injury. Well, I guess it was just injury on the washers case, but the governor of Korea then took the washers case to the WTO, and we were involved as a third party representing another government in that case, and the Koreans won at least some of the issues challenging the way that the dumping margins were calculated in the washers investigation. And so the United States is now involved in an implementation proceeding where they theoretically will recalculate the dumping margins. So you've got these really interesting interaction of domestic and international dispute settlement, which I find one of the most interesting aspects of this case, of these whole cases.
So I cut you off, Richard, because I had to let the judge speak. So if you have a question, go for it.
The comment, I just wanted to make one comment, and that may lead into a question, and that is the real-life applicability of what we're talking about probably was demonstrated yesterday when Sears Roebuck cut off Whirlpool after 99 years of selling their products under the Kenmore label for the mere fact that that Korean manufacturers could deliver the washing machines for 10% less than Whirlpool could. So that, the real question is, at least that's what it said in the press. That's what the press said. It was said in the press. How does that play into the various remedies?
Well, again, I can't say too much. I suspect that there's a lot more. If you pull back the curtain, there's a lot more going on in Sears. That's I didn't hear about that. Interesting development. The Korean companies say, and this is public because I don't represent them in this case, that they actually price higher. So the dumping concept is really interesting here because what you're doing is they're providing a higher quality product, they say, than Whirlpool and GE. And they also say that Whirlpool has destroyed the Maytag label. But the point is that they're doing a higher price, but not high enough, is the allegation, because the products are so good that, in effect, they're dumping innovation, if you will. That the prices should have been even higher than they are, even though they generally are, if you go to your local store, they are priced higher than GE and Whirlpool. The other point is that I suspect that Sears may rue that decision if import restraints on the Koreans are in fact imposed, because they're going to have to go back to Whirlpool in order to fill their floors of Sears, so they may be back.
The only thing I'll say, I've tried to show restraint because my firm represents Whirlpool, and we keep talking about the washers cases. But Whirlpool might say the reverse of what you said. I think you said Sears cut off Whirlpool. Whirlpool might say they decided not to keep selling those at Sears, for what it's worth.
Very similar.
For price.
Happening last week, which is the preliminary. The Commerce issued an affirmative preliminary ruling on Bombardier C-Series case, and then you see Airbus getting into is it a merger or a partnership where they are allegedly going to produce, they say in their press release, C-Series airplanes. I think in their plane
in Alabama.
In Alabama. Yeah. So. There's all kinds of things are getting a lot faster, and there's different attempts, but the trade statutes are there for the lawyers from the importer or from the petitioners or respondents bar to use, and you've seen a full gamut of all these additional remedies that are in addition to counterfeit eluding CVDs. We are adjourning our conference. We're going to have a 3 o'clock following coffee. We're going to have a 3 o'clock alumni panel where we're going to have some recent case log reads. And Richard is also a log read, but he's not so recent. So we're going to have some recent case log reads. But you're invited. But you're invited to. But you're all invited to come and see this panel with some rising stars that Case has produced and who are actually who are practicing in the trade field. And it would be especially good for students, but everyone is welcome to come back. Thank you very much.